Declare open this hearing of the Senate Education and Employment References Committee into the Wage Theft Framework under the Fair Work Act 2009 and the operation of Section 327A, subsection 1. I begin by acknowledging the traditional custodians on the land on which we meet and pay my respect to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via video conference and in person. I'm joined online today by the Deputy Chair, Senator Marielle Smith, and Senators Delegar, Barbara Pocock and Payman. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and as any such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. I remind committee members and witnesses who are appearing via video conference and who are not speaking to please mute their microphones. I now welcome representatives from the Australian Security Industry Association Limited via teleconference. I understand that information on parliamentary privilege and protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you each please state your full names and the capacity in which you appear today?
My name is Brian De Carys, and I'm the CEO of the Australian Security Industry Association.
I'm Maria Regas, and I am the Senior Workplace Relations Advisor for the Australian Security Industry Association.
I now invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions. Thank you.
Thank you for the opportunity. So the Australian Security Industry Association, we represent about 3,000 security companies providing services across a range of different services, including the protective security services sector, CIT, and electronic security sector. Our position in regards to wage theft is deliberate, intentional wage theft is unacceptable and should be addressed. However, I think we believe it's important to distinguish between intentional exploitation and widespread systemic drivers of inadvertent underpayment. And I think that's not to excuse underpayment, but to ensure that any response is proportionate, targeted, and effective, and actually preventing harm from occurring. I think as a result of the closing the loophole amendments, which were introduced just over a year ago, I think it's fair to say the workplace relations environment has become a little bit more complicated, and I think that's particularly so for the security sector, which is a 24/7 sector and works across multiple sites, irregular hours, penalty rates, allowances, changing client requirements. Makes it a fairly dynamic and a constantly evolving environment. And I think what we have seen is small payroll or classification errors can very quickly escalate into underpayment despite efforts to comply. So in our experience in terms of the assistance we provide to our members is that in the majority of cases, the underpayments are not deliberate, but they arise from ambiguity in the system, contested interpretations, payroll systems that have limitations in tracking this, and an ongoing sort of evolution of industrial instruments, which makes it more challenging for them to fully comply. I might now get my colleague Maria Regas to just make a couple more points, and then we'll open up to questions.
We are concerned that the current criminal framework risks blurring the line between intentional theft and compliance failure, particularly through the broad attribution of intention to corporations based on culture or systems deficiencies. Where criminal liability turns on outcomes rather than demonstrable intent, there is a risk that employers actively attempting to comply, audit, and rectify errors may nonetheless face criminal exposure with adverse consequences for transparency and early remediation. Further, the drafting of the offence captures intentional late payment, collapsing temporary delays into the same category as permanent deprivation. This departs from the fundamental criminal law concept underpinning theft and risks criminalising conduct that is better addressed through civil enforcement mechanisms. Late payment is unlawful and should attract consequences, but it is qualitatively different from conduct involving permanent deprivation. As an employer organisation, we support strong compliance outcomes. We invest heavily in the provision of education, advice, audits, and early remediation to our members. We also support enforcement against genuine, unscrupulous operators who undercut compliant businesses and distort competition, particularly in tender-driven industries such as security. In appearing today, our focus is on why complexity, not intent, drives much non-compliance, how criminalisation may undermine rather than improve compliance, why simplification and clarity are essential preconditions to enforcement, and why the wage theft offence should be repealed or substantially narrowed consistent with AI Group's submission. We thank the committee and welcome your questions.
Thank you so much. Your members operate in an industry characterised by extensive subcontracting and labour hire. Would you be able to walk the committee through how a typical security contract for a large venue or government client actually moves through a chain of contractors and where the compliance risks arise in that chain?
Sure. I think if you look at a major government contract, it really does depend on the contract. Let's say a major event. You often see a very short-term period that the additional personnel are required. So typically, the prime company may not have sufficient staff to meet 300 to 500 people, so they will look to subcontract. Depending on the terms of the procurement process, there should be full transparency and there should be full disclosure if there is subcontracting that will occur, and there should be full transparency to the client, whoever that is, the head client, that those subcontractors are going to be paid in accordance with all industrial instruments. So that is really what is I think the core thing that needs to happen is that there needs to be transparency, that where there is a short-term contract where someone needs 300 people, any subcontracted workers are required to be paid in accordance with all relevant industrial instruments, which in some contracts that transparency is not a prerequisite of the actual contract. And we would encourage that. If I give an example, we had to be put into we did a multi-employer agreement, for example, for the 2018 Gold Coast Games, which meant that everybody working at those games were covered by one industrial instrument. They were working for multiple companies, but they were all covered by one single enterprise bargaining agreement. For us, any subcontract, what you don't want to see is a passing on of subcontracted work to someone who gets paid less, and then someone gets less, and someone gets less. So there's multi-tiered levels of subcontracting. It is a legitimate way to operate having subcontractors when you have peak demand, but it needs to be done transparently and in accordance fully with all industrial instruments.
Thank you. And you noted in your opening statements the complexities that some of your members deal with. Your members currently navigate the Modern Award, the Fair Work Act, and separate licensing regimes in every state and territory. From your perspective and the feedback from your members, what proportion of underpayment in your industry is driven by that structural complexity and pricing pressure rather than a deliberate intent?
To be honest, we don't have an accurate figure. It would be an anecdotal figure. I would say the majority of it would be confusion or misinterpretation. I think the percentage that is deliberate would be a smaller percentage. But that's not to say there is no deliberate underpayment, but the vast majority are trying to run a business and they have got caught up in something which they have not fully understood. So we get the members ring us up with the queries, and our intent is to help them work their way through so they actually are compliant. So the vast majority that come in have not been able to, for example, the recent, the Anzac Day extra holidays, people are ringing up to say, well, what do we do with that? So things come up that was an unscheduled holiday in certain states. We need to help people work their way through that because it was not something they were planning for.
And so effectively your members are coming to you for assistance to ensure that they comply and can actually do the right thing by their employees as opposed to sort of seeking support afterwards when they've done the wrong thing, which may or may not have been inadvertent as well. So they're proactively attempting to navigate that complexity that you describe.
And they're seeking interpretations. They're just trying to work out because, as I say, some of them have, as you mentioned, there's state-based legislation for their licensing component, but then there's labour hire legislation in some jurisdictions. So they're trying to be compliant, and some of them do get a little bit confused. So they just say, can you just, they may be an SME with 10 or 15 staff. Can you assist us to make sure we do the right thing? Now, obviously, the people not doing the right thing most likely wouldn't ring us because they don't really hear what we have to tell them. So we don't know what we don't know. So again, how big that number is, it's almost impossible to ascertain. But what we try to do is through briefings to our members in face-to-face or bulletins or just over the phone advice, which is included in their membership, we are wanting them to be compliant. So if they have a question, we'd rather they ask it than not ask it. But I don't deal directly with Maria does more the direct dealing with members, but I think that's a fair characterisation. Yeah.
Very fair. So we will see members on a daily basis who ask us questions, or with the sole premise of wanting to be compliant rather than not.
So that was actually going to be my next question, Ms. Rigas, are you finding that a substantive amount of member engagement with you is around navigating the complexity of obligations and the awards?
Yes, pretty much. So a lot of the member queries that I log are around overtime night shift. They are misclassified casual. They are unpaid breaks for employees under the security agreements. Misinterpretation of public holiday, as Brian mentioned earlier, that happened recently and with a lot of members because the two holidays actually realised they needed to seek some advice, which most of them didn't.
Thank you so much. I will now hand over the call to Senator Delago. Thank you.
Thank you.
Thank you, Chair, and good morning to you both. My first question is in relation to the many high-profile underpayments across the security industry. I was just wondering if you could let the committee know how do the contractors that underpay or steal from their workers undercut good operators who abide by their obligations?
Thanks for the question. So I wouldn't characterise all of our members as doing something that is close to non-compliance. But
no, definitely not making that categorisation. I'm just asking, how do the operators that actually steal from their workers, how do they and undercutting from the good operators, What's the impact?
Yes, the impact is very varied and wide, and we are aware of a certain case that was publicised recently, of course. So the impact is wide across the industry because people who are doing the right thing, our members who are doing the right thing, are actually exposed to not being able to compete with the pricing from an unscrupulous member who is doing the wrong thing. And of course, all those do have an ability to unpack themselves and actually be detrimental. In which case, for the highly publicised one most recently that I can recall in the security industry, that is exactly what happened in that scenario.
Yeah, I think the issue is the transparency of procurement processes. What we're seeing, the protective security services sector has very low margins. So we're looking at a 3 to 5% margin is seen as a healthy margin, right? So companies that can get a competitive advantage through pitching work at prices that are really just too good to be true. The client needs to be, they need to do their due diligence because there's no way you can do that to pay people in accordance with the award and all the entitlements, and to have a margin to cover your overheads and legitimate business expenses. So what we see is some practices which has driven something of a race to the bottom mentality where people look for creative ways to avoid doing the right thing. So what we've had input into many different things. There's a security guiding principle document which the ANZ CTC has put up. There's a whole range of different. There is a best practice model, and that is about transparent procurement. And we would like to see that more prevalent. So legitimate operators can make a legitimate profit, and workers absolutely get all their entitlements.
Thank you for that. And previously, in answering to Senator Kovacic's question, you were talking about that a lot of your members are making contact and asking questions about complying with the rules and the different structures. What other measures is your organisation taking to be able to inform your members about the changes and these new laws?
So we've got a special industry group. We invite our members to attend, and a lot of them do. And we basically dissect specific legislation and what their obligations are under it. We do that on a monthly basis, and a lot of our members actually come because they don't have a workplace relations person in their remit. So they actually come to benefit from that knowledge, and most of them do. And subsequent questions, of course, are answered as well.
But certainly we have a range of different channels. We do, as I say, face-to-face member briefings across the country. We have a magazine that we write articles. We have member bulletins. We have a social media network of about 20,000 that we get out to employers. So we strongly believe that education is a key part of what we are here to do. We're not inside. We don't have the resources to be inside 3,000 businesses, but we can try and lead them to water. If they choose to drink it, that's their call, but we can only provide the information we can provide. And we certainly work with agencies, whether it's labour hire, Fair Work, to make sure we're saying the right thing. So we're not making up communication. We don't want to confuse the market, but certainly we go out regularly with information. I think some have felt a bit overwhelmed because obviously there has been a lot of change over the last 18 months. And then we've got other distractions such as the fuel crisis, which is challenging some with getting their vehicles on the road. So there's lots of different things they're trying to grapple with. So we want to help them through that process. But education for us is a key, but there needs to be consequences for actions.
Thank you for that. And just touching back to that high-profile case where the Fair Work Ombudsman put out a release in January last year alleging that a high-profile Perth security company committed serious contraventions of the Fair Work Act and allegedly stealing more than $900,000 from workers. And I think it was 44 security guards employed were affected. And the Fair Work Ombudsman has alleged that the workers were underpaid knowingly and systematically. Do you believe, from your organisation's perspective, that there should be a strong deterrent in place for companies that engage in this practice?
Absolutely, there should be deterrence for non-compliance.
Strong deterrence?
Yeah, well, we want to have a level playing field. We want people to be able to compete on the same terms. So if there are huge discrepancies, it's very hard to compete fairly. So for us, it's as long as people know what they should be doing. And I think one of the challenges is that people may not everybody may fully understand. But that's why, getting back to my initial comments, there is a marked difference between intentional and non-intentional. So there is a distinction there. And certainly if it's intentional, that's a very different thing.
So, yeah, so in relation... Yep, just in relation to that Perth case, though, that was, $900,000 in allegedly in stolen wages or underpayments So just wanted to get on the record that there should be a strong deterrent because the Ombudsman has alleged that they were underpaid knowingly and systematically.
Section 327 is the deterrent there, Senator. So that captures offences that are deliberate conduct, which of course this one, by the sounds of things, was. But honest mistakes, payroll errors, misinterpretation of complex award provisions, those of course do not fall under 327. But if anything is deliberate or an intentional practice, knowingly and systematically, as you mentioned, then we're totally concurrent with the 327B.
Thank you very much. Thank you, Chair.
Thanks so much. Senator Barbara Pocock.
Thank you, Chair, and thank you both for being here this morning. I just wanted to hear a little more about your view of the 327 provision. I want to understand clearly what your view about it is. You talk about that one particular case where the language of knowingly and systematically was applied by the Fair Work Ombudsman, I understand. So you support that provision, is that correct?
Yes, Senator, we do. We support it insofar as the offence is aimed at deliberate conduct. So if anything is deliberate and it actually undermines what Australians are being paid and rightfully not being paid correctly and appropriately, then yes, we do support 327. But if it's an honest mistake, a misinterpretation of complex award provisions, an inadvertent underpayment, those do not constitute wage theft.
Thank you. And if I reflect on your commentary on margins in this sector, you have 3,000 affiliates or members, I understand, and your margins are very tight. I imagine entry-level costs of coming into the industry are relatively low, so people can come in and out, but it is a strongly competitive environment. Have I understood that correctly from what you've said?
There's many different sections of the industry. The protective services side, where there is security officers and major events, shopping centres, that is particularly that's where most of the licensed security personnel work. There's an electronic sector, which is a much higher margin sector.
Yeah.
But that's we've got about 3,000 members. To give you a bit of perspective, there's about 13,000 security companies across Australia offering electronic security, physical, protective security. So it's a sector that has grown probably from about 40,000 licensed personnel in the mid-90s to 170,000 in the end of last year. So over 30 years, it's increased significantly.
So it's a significant group of businesses and employees, and it's extremely competitive with tight margins. So isn't it likely then that the business model encourages the overlooking of proper payments. Your sector has, it looks like, certainly a higher incidence than many other areas of industry on wage theft. It's got a profile there which is many Australians are conscious of and has realised quite a bit of attention in the media. Isn't the business model pushing it that way? Even if that is not necessarily the way you'd like to do business, tight margins like that mean that you might be inclined to overlook something and hope no one catches you. Is that part of the operating modus operandi in such a tight market?
I think it's probably unfair to characterise the whole industry like that. I think what we see is that the lack of diligence within the procurement process that drives it. So some of it is customer driven. People want to pay the lowest amount they possibly can. So what we would encourage is a greater diligence in the actual procurement process, and we see that with some clients who are more thorough in terms of who they engage and what they are going to provide, and if there is a spike in demand, how are they going to fill that spike in demand with additional staff? Are they going to be paid in accordance with the relevant industrial instrument? And that should be in the agreement, and it doesn't always happen. So what we then have is it's a much more complex environment to compete against because it's all price driven, not quality driven. And we're all for people getting best value for money, but it has to be done legitimately. And it's a difficult industry because a lot of it is on demand because people don't know what the security threat's going to be. So if it's a major event, they may need to change the risk profile by 10%, 20% because of whatever the threat environment is at the moment. So, and the threat environment does change, whether it's a shopping centre, whether it's a major rally that needs some additional security. So you need to have that flexibility, but it just needs to be transparent, that we do not have the ability for people to work around the law of what they should be paying.
Thank you for that. I mean, all of that seems to me to mount an argument for very strong regulation of the service provider because we cannot rely on the procurer to be the enforcer of decent labour conditions and proper wage payment and the avoidance of theft. It has to be with the business providing the service because procurers don't approach a contract with the perspective that they must make the supplier meet the law. That's the supplier's response. So I think what you're saying is a strong argument for good, strong regulation and law. I want to go to another comment that you made, which was that there was a blurred line around the criminal elements of this bill. Can you say a little more about what you were intending in that comment?
Did I say that or did you say that?
No, I said that. Senator, the blurred line, so I guess from even a perspective of record keeping, so say, for example, we saw the case with UNSW in 2026 and the fact that record keeping and compliance, they were actually penalised for systemic record keeping failures that impacted underpayment investigations. So just from that perspective alone, there's a blurring of the record keeping needs to be really tight. And of course, larger organisations such as Woolworths and Coles are being treated with the same scrutiny as smaller hospitality underpayment cases, just as the one of Fair Work Ombudsman versus May. So I guess the blurring that I was referring to was that record keeping needs to be as strictly monitored as anything else to make sure that there is data integrity. So
can I thank you for that. Can I ask you then about how you think the civil penalties regime is working in your sector relative to the criminal penalties? Is there any comment you want to make about that?
And just quickly, Senator Pocock, I'll need to rotate the call after this one.
That's my last question. Thanks, Chair.
The civil penalties that we're seeing, even the 327 criminal ones, they're actually we've seen very few prosecutions. But with the civil, I'm before the Fair Work Commission on a daily basis for my members. We try to get the best outcome depending on what the situation presented to us is. So there is a lot of the civil, and of course we've seen very little of the 327 criminalisation. So that may change in the future. Is criminalisation the deterrent? Not entirely, because you have to make sure that people know what their mistakes are before the criminalisation is. Because if they don't know, they're going to do it irrespective of the criminalisation taking.
Thank you. Thanks, Chair.
Thank you. Senator Payman.
Thank you, Chair. Good morning, all. And thank you for providing the evidence so far. I'm not sure if you have read Mr. Andrew Burke's submission, where he details numerous cases of wage theft in the security industry in Queensland, which led to substantial fines. As a senator for WA, would you provide some context about, what the extent of underpayments are within the WA security industry?
I haven't, I'll be honest, I haven't read Andrew Burke's submission. And in terms of the extent in WA?
We've seen one member, but it was not wage theft. That member just wanted granularity on the applicability of the award for cash in transit. And we gave them the guidance. We reviewed a few materials that they were intending on submitting to their officers. And that was the extent of our advice in WA.
Okay, and that precludes the, that doesn't include the alleged case before the Fair Work Ombudsman?
No, I haven't been spoken to about that particular case. I'm sorry, Senator.
No worries. And just off what Senator Barbara Pocock was asking, many submissions indicate that the security industry uses wage theft as a business model. And I would like to know your opinion on to what extent do you believe that, in their zeal to win contracts, security companies in Australia make offers which preclude the possibility of paying their workers what they're entitled to?
I think going back to Senator Pocock's question before, the industry is heavily regulated. So we have state and territory-based industry regulation. In some jurisdictions, we have labour hire regulation. Obviously, we have the Fair Work Act and other regulatory models. I think there is it's definitely a very competitive market. But we've done campaigns certainly in the past with Fair Work to try and educate. We did one, a local government procurement initiative back in 2016, 2017, which found, I think, 60% non-compliance within local councils. There is, there certainly is a strong environment where the people are not, within the procurement side, are not willing to pay the rates that it should be paid to legitimate companies. So that makes it very difficult for companies to compete. But that's why we provided guidance on. It's difficult. We can't say a price because that's obviously we can't fix what a price is people should pay. But there's certainly there is the award, plus there are on costs that companies have to meet to cover insurances, offering the different services they provide. But again, whilst I agree, it's partly the providers are part of the problem and the solution. But likewise, customers are part of the problem and the solution, and they need to be part of it. And we certainly look to government agencies, federal and state, to lead by example in terms of how they procure security.
And that's my follow-up question. Do you think that the onus and the way government's held to account when they are the procurer, is that up to standard? Is that up to scratch?
Well, I think we could certainly improve things because it's an industry that is growing in demand. So more and more people are using security services. and we're seeing that growth continue. And certainly we have some major international and global events coming up in 2032, where we will see a significant workforce that's going to be required for those gains. We need to get this right to make sure that the right people are winning the contracts who are able to deliver that service and absolutely pay their staff as they should be paid.
Absolutely. So just on the introduction of the offence, would you see that as a, I don't know, performative reform, a change which served to publicly signal the government's opposition to wage theft rather than actually addressing the incidence of wage theft in Australia?
I mean, I think when it comes to certainly the protective services side, there needs to be a cultural shift in terms of, these are people who are doing a valuable job, and they need to be remunerated appropriately. And so the actual whole procurement process and the models that are put in place need to reflect that. I need to make sure there are appropriate checks and balances to make sure people are required to do the right thing.
Yeah, no, absolutely. And just finally, in estimates in February, I discovered through a line of questioning that the Fair Work Ombudsman has not referred a single criminal wage theft matter to the police, despite obviously the investment of almost $50 million over 4 years from the government, which is funding an office of like 16.7 full-time staff to investigate criminal wage theft. Do you believe this is an effective use of taxpayer dollars, or might these funds and investigators be more effective at addressing wage theft if they were deployed elsewhere?
Senator, if I may, if the goal is prevention, not just punishment, then clarity, simplicity and usable systems are just as important as penalties. But it definitely serves a purpose, just not in the majority, but in the minority.
And so would you say that, I don't know, the bill and all this investment is actually filling that education gap and addressing or spreading that awareness?
I think with awareness, there may be a little bit more work to be done. There are a lot of people who, for example, the criminal offence is a significant shift, but its effectiveness will depend on whether it can be applied clearly and consistently in real world, which we've seen at the moment it can't be, and it isn't.
Thank you so much. Thank you, Chair.
Thank you. Thank you for your evidence today. If you have taken any questions on notice, could you please return the answers to the Secretariat by Monday, the 18th of May, 2026. Thank you for your time.
Thank you.
I now welcome representatives from the Shop, Distributive and Allied Employees Association and the Australian Council of Trade Unions via video conference. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you each please state your full names and the capacity in which you appear today?
Yes, Dr. Anthony Forsyth. I'm the Senior Legal Officer with the Australian Council of Trade Unions.
Thank you.
Gerard Dwyer. I'm the National Secretary-Treasurer of the Shop, Distributed and Allied Employees Association.
Thank you. I now invite you to each make a short opening statement if you wish, and at the conclusion of any remarks, I will invite members of the committee to ask questions. Thank you.
Well, thank you, Chair. I'll begin by acknowledging the traditional owners of the lands I'm joining you from, the Wurundjeri people of the Kulin Nation, and pay my respects to elders past and present. The ACTU welcomes this opportunity to contribute to the committee's inquiry into wage theft. The introduction of criminal liability for wage theft by the Albanese government followed over a decade of heightened attention to widespread underpayments by employers across Australia. The new offence of intentional underpayment in Section 327A, introduced by the Closing Loopholes Act, took effect on the 1st of January last year. Significant increases in civil penalties for underpayment were introduced by the subsequent Closing Loopholes No. 2 Act. In our submission to the current independent review of the Closing Loopholes laws, which is also considering this new criminal offence provision, the ACTU said the new criminal offence is an appropriate measure to combat wage theft, but given that it's only been in operation since 1 January last year, it's too early to assess its effectiveness in deterring employers from engaging in wage theft, and that remains the ACTU's position now. We support the approach of civil and criminal liability measures to crack down on the theft of workers' hard-won wages. This inquiry was triggered by evidence in Senate estimates in February that the Fair Work Ombudsman hadn't yet referred any matters to authorities for prosecution under the new laws. The head of the Australian Chamber of Commerce and Industry, Andrew McKellar, suggested this was evidence that claims of widespread wage theft were wrong. Actually, the evidence still tells us otherwise. For example, a Melbourne Law School study published last July found that wage exploitation was rife in its survey group of almost 3,000 young workers. 33% of respondents in that survey were underpaid, receiving $15 per hour or less, compared to the then minimum wage of $25 per hour. More recently, Australian Border Force's Operation Odin found that more than half of over 300 regional hospitality businesses were non-compliant with workplace laws in their treatment of migrant workers. Turning to the FWO's role, the ACTU isn't aware of the commencement of any prosecutions for the new criminal wage theft offence. The Ombudsman confirmed in Senate estimates late last year that it had 2 active investigations underway. We don't really comment on whether the Ombudsman should have already carried out more investigations and made referrals for prosecution of the offence of intentional underpayment. It's too early to know if the recent criminalisation of wage theft has had a deterrence effect on employers. But we think these issues could be examined as part of a wider independent review of the Fair Work Ombudsman, and this is recommendation number 1 in our submission. The scale of wage theft continues to mean that other solutions are necessary. Unions play a vital role in combating wage theft, but with a fraction of the Ombudsman's resources. For example, the SDA, who you'll hear from soon, recovered more than $20 million in unpaid wages for members in 2023-2024. The United Workers Union recovered over $67 million in unpaid wages for members in the last 5 years. But unions face serious challenges in doing this important work. Firstly, the time involved in preparing underpayment claims is extensive. It involves laborious work in compiling and analysing the evidence of hours worked and pay received for each employee. Secondly, legal proceedings are lengthy and costly. Our affiliates report that it can take between a year and 18 months to get cases to trial in the Federal Circuit Court or the Federal Court. The procedure for small claims, recently increased to up to $100,000, has improved things, but it can still take around 6 months to have a matter heard. Filing fees of between $300 and $560 can also prevent workers from bringing a claim. Overcoming these challenges could be assisted by implementing our other recommendations to make further progress towards ending wage theft. Quoting 2 scholars in a journal article referred to in our submission, criminalisation must be accompanied by civil remedy mechanisms that empower workers who seek to recover their unpaid entitlements. Accordingly, our second recommendation is that the government investigate ways to simplify and streamline judicial processes to reduce the time and expense required to run underpayment claims. Despite recent reforms, including expansion of the small claims jurisdiction, as I mentioned, workers still face obstacles in accessing wage justice. To help deal with those issues, there is our third recommendation that the Fair Work Commission...
Dr. Forsyth, I'm just mindful of question time for senators. Would you like to table that, or have you only got a little bit to go?
It's my very last point.
Oh, wonderful.
Very
Thank
quickly,
you.
Chair. I apologise for going over time. Third recommendation is that the Fair Work Commission be empowered to play a role in resolving underpayment claims through a process where a registered union could initiate this process prior to proceedings in a court, and giving the Commission powers to obtain employers' time and wage records and require independent audits to establish the quantum of underpayments that could then be resolved through the Commission's existing powers in relation to conciliation. Thank you, Chair.
Thank you. The Shop Distributive and Allied Employees Association, do you have an opening statement?
Yes, Chair.
Please proceed. Thank you.
Thank you, Chair, and thank you to members of the committee for the opportunity to appear today. I also appear with Mr. Robert Tonkley, the Chief of Staff in my office, who's got over 20 years' experience as a full-time official and has worked heavily in the preparation of this submission. The SDA represents workers across retail, fast food, warehousing and related industries, sectors that employ large numbers of young people, casual workers and those in insecure employment. Our core message to this inquiry is straightforward. Wage theft in Australia remains widespread, entrenched and largely unchanged in its prevalence, despite recent reforms, including criminalisation. As set out in the SDA submission to this committee, wage theft continues to take many forms. Underpayment of wages, unpaid overtime and penalties, unpaid trials, record falsification and widespread non-payment of superannuation. These are not isolated incidents in our experience. They are often systematic practices embedded with particular business models and industries. The evidence before the committee confirms this. Estimates put the cost of wage theft to the Australian economy in the billions of dollars each year, while recovery figures demonstrate not deterrence, but the sheer scale of ongoing non-compliance. Young workers remain the most exposed cohort. That recent research referred to by Mr. Forsyth shows that around 1/3 of young workers are likely to be underpaid, with significant numbers missing out on superannuation and working unpaid hours. These workers are also the least likely to report breaches, often due to fear of losing shifts or employment itself. We also emphasise that the non-payment of superannuation must be treated explicitly as wage theft. It is deferred wages, and the current fragmented enforcement arrangements between the ATO looking after super and the FWO assigned to wages, this fragmentation allows a form of wage theft to persist at scale with billions of dollars in unpaid superannuation each year. Fragmented enforcement clearly doesn't work. A key finding of our submission is that a regulator-only enforcement model is not capable of addressing wage theft at scale. The Fair Work Ombudsman performs a role, yes, but its compliant-driven model and resource allocation mean that a significant proportion of breaches are never detected nor remedied. To address this, the SDA's position is that Australia needs a stronger, more industry-focused enforcement framework. In particular, we recommend restoring the rights of registered organisations to inspect time and wage records and conduct routine spot checks. This would enable proactive detection of underpayment and provide a practical, cost-effective compliant mechanism across high-risk industries. We also support the establishment of an accessible small claims jurisdiction, allowing workers and, importantly, their unions to pursue unpaid entitlements through a simple, low-cost and timely process. And finally, Chair, while the criminalisation of wage theft is an important development, we agree that it is too early to conclude whether or not it has materially reduced underpayment. The structural drivers of wage theft remain, and without stronger enforcement mechanisms, deterrence will remain limited. In summary, wage theft continues to be a systematic issue. Addressing it requires not only penalties, but effective, accessible and proactive enforcement. Thank you.
Thank you, Mr. Dwyer. I'll now go to the Deputy Chair, Senator Muriel-Smith.
Thank you, Chair, and thank you both for your evidence today. I'll be directing my questions to Mr. Dwyer, but of course, Mr. Tonkel, if you're best to jump in, that's fine with me as well. But as we know, our government criminalised wage theft following a number of very high-profile cases of the intentional underpayment of workers across Australia. There are a number of key case studies which your union has been prosecuting, and I was hoping we could go into these in a bit more detail, particularly, in some of the recent high-profile cases that you've been involved in. If you could talk to some of those, and then I'll have some specific questions on each.
Thank you, Senator. The high-profile cases that we've been involved in, and some of these go back, for example, quite some time to 7-Eleven, and which I think has certainly focused both unions, regulators and legislators on what needs to be done. In more recent times, the prosecution of Aldi supermarkets in terms of warehouse underpayments, which was a matter of working off the clock, i.e. unpaid overtime. That was quite significant, and that has been drawn to a close. But if we had a different system, i.e. an employment court which we could deal with, now that matter would not have satisfied a small claim. It went into the millions. But we'd like to envisage that an employment court or something similar would actually be able to deal with both small claims, but also allow unions to prosecute on behalf of whole classes of employees, like the Aldi matter. And that, by definition, will run into far more money when you're dealing with hundreds and thousands of employees. People would be aware of a high-profile case against McDonald's. There's 2 class actions at the moment, one on unpaid breaks. There's another, though, on unpaid working time, which is less progressed, but nonetheless very important. One that has concluded more recently was KFC, and that went to unpaid breaks. Again, with close to $29 million being recovered, that was in excess of a small claim, but I think demonstrated the need for a system to allow a registered organisation to proceed with an action on behalf of a large number, in that case, a whole class of employees.
Mr. Dwyer, you mentioned in your testimony that it's often young workers who are affected by wage theft and these wide-scale wage underpayments. Do you have any other figures you can share with us in terms of the number of workers you expect that you represent across the sectors that you advocate for are impacted by wage theft? And in some of these examples, for instance, like the McDonald's case or Audi, how much were workers underpaid in a dollar amount?
Well, the Aldi, Senator, the amount per worker will vary depending on the number of hours. The Aldi figure was that was in 10 million, and that's a gross figure. With regards to the KFC figure, again, that will vary depending on the number of shifts worked by an individual employee. That process is underway at the moment in terms of disbursement, because the total sum, which is the close to 29 million, that is now being dispersed. So the actuaries are having a look at how this is to be distributed. But we expect that will represent, on average, between $200 and $300 per employee over that 6-year claim period. So that's significant money for each individual. But I think when you have a look at, say, that, let's say it's $300, if that individual, right, was to proceed with court proceedings to recover a $300 claim, the current system is simply not worthwhile. By the time you've paid a filing fee and hired a lawyer, most people then just walk away from it. That would cost them more to enforce it than it would the recovery amount. So I think that's a really clear example as to why we need a small claims jurisdiction, which is low cost and very timely. I think Mr. Forsyth's observations of the amount of time it might take to actually get to hearing is quite makes it quite difficult, particularly for young workers who haven't got many savings. If they've been underpaid, they deserve the money paid to them, but to be paid to them quickly.
Thank you, Mr. Dwyer. I mean, I'm interested in what you've seen to be the impact of these laws. I mean, the laws came about following the advocacy of workers across Australia who saw an urgent need for these kind of protections and provisions to be in place. So I'm interested in your experience as the leader of a union in how they're having an impact in terms of what you're able to do on behalf of your members and what you're seeing, and also in terms of what message you think these laws send to employers?
I think the laws have been definitely a very big step in the right direction. We are seeing, I think, greater awareness amongst younger workers of, with underpayments, have they got somewhere to go? Publicity around cases is always helpful. It's a clear signal to particularly younger members that if you've got a problem, you can raise it. I think what it does underscore, though, is the what we're finding and what we're prosecuting, or the space we're prosecuting in, it's representing people in largely non-unionised workplaces. Wage theft in a unionised workplace is not as common. Okay, in fact, it is addressed very quickly. There are processes in place in those workplaces. A matter is raised because people have got a licence. A union coming into a workplace and having an enterprise agreement, and that's on the back of new bargaining laws, which have been most welcomed in terms of spreading enterprise bargaining. Where you've got an enterprise agreement, there's a greater openness. The culture inside those workplaces is different. People feel like they can put their hand up, so they will go and raise an underpayment issue, either with their delegate, stroke shop steward, or even individually. And our experience is that's dealt with fairly quickly. And if not, then the full-time official comes in and they will deal with it quite quickly. But unfortunately, most of the problems, like the Howe and Dillon report from July last year in the Melbourne Law School, those quarter of young people that aren't getting paid their superannuation, or approximately a third that are doing unpaid work, most of them are in non-union workplaces, which brings us back to our point. We need the capacity to go in and do spot checks as we used to decades ago. And I think that's instructive, because decades ago we didn't have a wage theft epidemic like we do today. Unions were able to properly represent individual workers and also properly protect responsible employers who paid correctly. They knew that there was a cop on the beat down the road in the form of a union official going in and doing spot checks in that industry to ensure that everyone was complying with the rules.
Thank you. Just one more question before I pass over the call. What do you say to the claims of some that these laws capture businesses trying to do the right thing, or that these laws impact upon business viability?
I don't accept that at all. These laws are really trying to capture businesses that don't do the right thing. Our experience is that businesses that do the right thing have got nothing to fear from these laws. And in fact, the more powers that registered organisations have to enforce minimum wages right across their industry, that is a good thing for them. And I actually think enhances their viability. What happens, particularly with smaller businesses, where you've got, say, a small business operating in retail, that's a business down the road underpaying their staff and getting a competitive advantage on cost because they do that. That is a bigger threat to that small business than any of these laws. I mean, laws that allow for enforcement and then penalties on top, they're important and quite critical to ensuring that we have a level playing field for business.
Thank you. Thank you, Chair.
Thank you. Senator Barbara Pocock.
Thanks, Chair, and thank you both, Dr. Forsyth and the SDA for being here. Much appreciated, and for your evidence, Mr. Dwyer. I wanted to go to your submission and ask you particularly about your use of the term fissured workplaces. It seems to me, reading your submission and the ACTU submission, that what we are seeing and trying to respond to here is not just an obvious high level of wage theft, especially amongst vulnerable workers, young workers, migrant workers. But it is a step change from 20 years ago because of the changed structure of employment. And I think that is convincing evidence for the need for new forms of regulation of the kind you've just been talking about. So I just want to hear the evidence on how things are different, making the case, therefore, for a different kind of regulation, not just criminalisation, but also other cops on the beat, as to use your language. Ms. Dwyer, can you comment on the changes that we're trying to deal with here?
Thank you, Senator. Yes, if we have a look at the changes in the last 2 to 3 decades, yes, we do. We do have to deal now with not just migrant workers. We also, though, I guess, look at those that are on visas. The use of visas in workplaces does bring its own level of insecurity, and we have had some changes there in terms of being able to have some cover from migration law if a person raises an industrial issue. But I think there is more work to be done there to send a signal to those types of workers that they can have more confidence in being able to raise their hand and bring a problem forward. We are dealing with people who are instinctively quite intimidated by regulators and often scared. And that's something that the law needs to take that into account and ensure that those people have got access to workplace rights. Again, I would submit that the registered organisations inside industries, like those unions that operate in their sectors, they need to be given the powers to actually be proactive, go in and do the spot checks, because if I'm young, if I'm a migrant worker on a visa, I am going to be quite reluctant to put my hand up. The young, not because of necessarily their employment relationship, albeit when they're casual, they are vulnerable, but they're also young and often lack life experience and the confidence to go and raise those issues. So we do need to get a legal framework that allows the industry player, in this instance the unions, to be able to be proactive to ensure that level playing field is established. Apologies, Senator, there was something else in your question that you wanted me to address.
I think I wanted you to address the changing nature of work, which makes this form of regulation so critical in addition,
Yes. So the changing nature of work, the increased casualisation is the most obvious issue that we have to deal with in retail and fast food, less so in warehousing, but particularly in those two. The other change, I guess, is people refer to it as the gig economy, which affects many industries. Okay, but that is something that is proving really difficult for workers because, and I think there's been some great work done in terms of the introduction of employee-like to try and capture and better regulate people working in that space. But I think we as a community owe it to any worker, be they a gig worker or on a visa or young, we all owe it to them to ensure that their rights are upheld. And unfortunately, particularly in that gig space, it's just an arms race in terms of the law trying to get around any form of accountability when it comes to wages and conditions. And so there have been some steps in the right direction, but I'm sure everyone would agree it's an area we need to continue to look at.
And I think your evidence is very explicit about the criminal offence and 327A. And I just want to quote you that the offence is narrowly framed and requires proof of intentional or reckless conduct, which creates a high evidentiary threshold that is poorly suited to the most common forms of underpayment, which more often arise through systemic payroll practices, misclassification, and so on. You're making the point there that while the criminal offence is there, it's incredibly hard to meet, and we are seeing that in the low rate of, well, we don't know how many investigations I understand are underway, but certainly the absence of prosecution. I just wonder whether you or Dr. Forsyth want to make any comment about, I mean, you're really suggesting we need a small claims tribunal and we need a cop on the beat in the form of a registered organisation representative. Is there anything else you want to say about that high threshold and its absence of really remedying this growing systemic problem?
I'd only add, Senator, that if you had the industrial organisation as the cop on the beat, and if we had a more streamlined and efficient small claims jurisdiction in which to prosecute employers, I think then going through those processes will actually build evidence. So then we might find that the evidentiary threshold is appropriate, or we may still find that it's too high. I don't know, but as I said in the submission, that it's probably a little too early to tell. But I think we need to do work on the foundations and get those foundations right, and then let's see how the criminality components work.
Yeah, I can.
Anything you want to?
Yeah, I can add to the issue around
the final question, Senator Pocock. Thank you.
I'll make it as quick as I can, Chair. There is a question around the high threshold of the test under the new criminal wage theft offence. If we compare it, for example, to the Victorian offence that was in place for a few years, which had a lower threshold around dishonestly underpaying and also had a recklessness component. But as we say in our submission, we don't know yet in terms of whether the way it's framed in Section 327A is too high. We think it needs more time to see what emerges in terms of prosecutions that may come forward in relation to employers who may be suspected of having committed that offence. But it is part of the reason we think an overall holistic review of the situation here may be very helpful in terms of the mix of higher civil penalties that have been introduced also under the recent changes to the legislation. How is the small claims procedure operating now that it's been lifted to $100,000? And whether there is room for the Fair Work Commission, which deals with awards daily and exercises conciliation powers, could play a helpful role here.
Chair, can I just ask one more question?
Sure, go for it.
You made a comment, I think it was you, Mr. Dwyer, about the fragmented enforcement arrangements between the ATO on super and the Fair Work Ombudsman on underpayment of wages. Is there a proposition you have about how that fragmentation can be reduced? Because clearly there is a major problem around super here and we're not catching it at the moment.
Thank you, Senator. Yes, the fragmentation should cease. The ATO shouldn't be playing a role in this space. We would say that the underpayment of super is far better addressed if superannuation is treated as deferred wages, which is what it is, and that the enforcement is via the industrial system, and we'd be enforcing unpaid super as we'd enforce any unpaid wage.
Thank you. Thanks so much for your evidence. Thank you, Chair.
You're welcome. Thank you. Senator Payman.
Thank you, Chair. Good morning, Mr. Dwyer, Mr. Forsyth. Thank you so much for the evidence you've provided so far. Just on the wage theft, the underpayment of super as wage theft, you have noted, and obviously in the previous question to Senator Barbara Pocock, but also there's been many submissions that say that ATO estimated $6.2 billion of super not paid in 2022 to 23. And we have seen that to be a substantial rise from the $3.7 billion estimated to have been stolen from workers in 2017 and 18. You were sort of briefly saying what can be done about it, but why would you say, why is super theft on the rise, and what can be done through perhaps this piece of legislation about addressing underpayment of super?
Thank you, Senator. I guess to put it simply, the Australian Taxation Office, we'd say, isn't set up necessarily or adequately to be a proper enforcer of unpaid wages, which is what super is. Their processes seem to enable great lengths of time to pass before someone might get some feedback. We've had examples of members raising unpaid super with the ATO. This is prior to them being members. Those matters, and then getting letters. But the first acknowledgement of it can be sometimes several months from the time that you raise it, and then in an inordinate amount of time before any sort of action seems to take place. And super, all of this unpaid super over several years means the money hasn't been in my account and hasn't been accruing interest and compound interest. So therefore, my retirement savings have suffered during that long period of time. Anyway, our proposition is simple. Super is wages, and the enforcement of unpaid wages should be in the industrial system. And within this industrial system, we should all be turning our minds to making the enforcement and recovery of wages simpler, more timely, and less costly.
Thank you. And I note that SDA submitted that wage theft continues to occur on large and entrenched scale, and that criminalisation has not yet led to a material reduction in underpayments. Now, both the SDA and NTEU also submitted that unions should be empowered to investigate wage theft matters, with the NTEU going further to suggest unions should be able to refer potential offences under the Section 327A to the AFP and CDPP. Now, taking both the submissions together, is it merely a matter of time before the offence has a deterrent effect, or would you say that there are other structural changes that are necessary? And to what extent would expanded union investigation and referral powers might be part of the answer, especially when it comes to putting it into practice and given the high standard of proof required under Section 327. And Mr. Forsyth, you can also jump in if you'd like.
Thank you, Senator. I might just deal then with as you said, I mean, it is still, to us in legislative terms, it is early days, or still early days, with regards to the Section 327 provisions, but would like to think that if we can get the foundation correct, we would actually then, I think that would provide some assistance in terms of focusing in on those very serious, systematic underpayments, but we'd also like to think that some of the threshold questions, or those thresholds, are lowered to make it, I think, easier to succeed in such a prosecution. But the structural changes that you ask about, I just come back to, we need to have laws that allow the registered organisation in each sector to give them the powers to go in and be part of the solution of cleaning up wage theft. We need to have the powers. Those unions are in those workplaces regularly. We have in workplaces nearby, so it's quite efficient to be able to go across and conduct a spot check, particularly in communities where conversations will often point to, we know so-and-so is underpaying. The current laws, though, unless we've got a name from a person and their imprimatur to proceed with that, they feel exposed, they don't want it, and therefore all we can do is refer it to the Fair Work Ombudsman, or it doesn't get attended to. and I think that's an unsatisfactory outcome. So we need to have an expansion of the powers that industry unions have to enforce wages in their sector.
Yeah, thank you.
Yeah, I'd probably add to that in our view, it would be unrealistic to expect that the introduction of the criminal wage theft offence would already have led to a reduction in the incidence of wage theft. We need to see how it operates over a longer time frame, I think. But what we won't accept is that this means there was never a problem to be dealt with in the beginning. The evidence is just so clear from the countless inquiries that have been conducted over the last 11 and 12 years at federal and state level, just how widespread and systemic this problem is. In terms of the role for unions, in addition to what the SDA has put forward, as we've said, we think there is a role for a registered union in being able to help a person who thinks they've been ripped off in terms of their wages find out how much they ought to have been paid, do that laborious work, help them do that work of calculating what the underpayment should be, and then seek redress for it through an accessible process that doesn't take months in the federal court system. And that's why we think being able to utilise the powers of the Fair Work Commission to help workers get that evidence together, work out what the appropriate amount of the claim is, and then have that body help conciliate the claim. At the moment, we have a model where it's the Fair Work Ombudsman that essentially provides workers with resources to help themselves in terms of working out what, if they've been underpaid and if so, by how much, and then has what's called an assisted voluntary resolution process where they try and get the parties to reach an outcome. We think a better process could be utilised in the Fair Work Commission.
Thank you. And just quickly, I'll refer to the Victorian Trades.
We really need to finish up here, Senator Payman. Yeah, thank you.
Okay, I'll put the rest of the questions on notice, but just on the submission by the Victorian Trades Hall Council, when Victoria criminalised wage theft, the task of investigating was given to a new body, the Workforce Inspectorate Victoria. Now, to what extent do you agree that with the Victorian Trades Hall Council's view that the Fair Work Ombudsman has a history of taking a light touch approach to enforcement?
Well, there are instances where we could see perhaps the Ombudsman may have taken a tougher line. I think back to the George Calumbaris wage scandal in his restaurants in around 2019, where what the Ombudsman did was to enter into an enforceable undertaking under which a contrition payment, from memory it was around $200,000, had to be paid, an admission of liability and the introduction of measures within that organisation, such as training of managers, better compliance systems, better payroll systems was required. There have been other similar examples of that over the years. And that's where I think perhaps from the union point of view, there has been a view that in certain cases the Ombudsman hasn't gone in hard enough in relation to wage theft. But certainly now with the existence of the criminal offence, there is plenty of opportunity for the Ombudsman to prove those criticisms wrong.
Anything you'd like to add, Mr. Dwyer?
No, Senator. I'm not particularly familiar with the Victorian jurisdiction and the laws you talk of.
Okay, no worries at all. Well, thank you, Chair. I'll put the rest of the questions on notice.
Thank you very much. Just a couple of quick questions for me, noting we're a little bit over time. And I'm just interested in an insight from either the SDA or the ACTU in relation to what your views are on how the regulations could be streamlined to make it easier for businesses to comply, to ensure that we neither have, the inadvertent underpayments or the wage theft that we're seeing.
Chair, my comment on that is that would require a lot of detail, I guess, to put on the table to properly answer that.
Sure. I'm happy for you to take it on notice, but also speak generally to it if you prefer.
Well, yes. And my general comment would be this, that I sometimes feel as though people try and make this more complicated than it actually is. For example, when superannuation was 10%, we still had an enormous amount of unpaid super. And I would often say that to employers. So what is difficult about calculating 10%? The fact is there was a culture that emerged that this was somehow an optional payment. So I think streamlining of regulations and reviewing of regulations is always a good exercise to undertake. But I think too much is made of what, in fact, is not that complex. What we have, though, is, I think, a rising culture whereby it seems to, if whatever you can get away with, you should. And particularly super has been seen as optional, and working off the clock, everyone should put in an extra half hour in the good of the business, and these sorts of cultural dynamics, which are...
That's a little different, though, to the evidence from the first witness who suggested that, they have their members coming to them trying to understand and even most recently with the most recent public holiday, how do they apply what? So I do agree there are people doing the wrong thing deliberately, but I guess my question is more around how do we assist those who do want to pay their employees right? How do we make it simpler when they are getting it wrong? We've seen examples of large organisations like the Commonwealth Bank and the National Australia Bank who make errors with large HR teams. So then to your point about streamlining regulations, how could we streamline them to make them simpler to understand so that people get paid the right amount, particularly those, who act in good faith and want to pay their employees properly?
Again, with regards to the regs and the specifics on each one, I couldn't answer that directly. But with regards to addressing this problem, I think there is a cultural part to this. Even those who are wanting to do the right thing need to then, I think, get their head around the fact that when they're in business, they pay very close attention to taxation law. They need to pay similar attention to industrial law. And I'd submit that the industrial law is actually far less complex than tax law. It does require a sense on the business parts to understand that they are responsible in this to get on top of the laws in this space. And as I said, it's not as complex as taxation law. So I might just leave my comments at that.
Sure. And look, and I do understand your point, but I guess also I've had evidence in estimates where, the Department of Employment and Workplace Relations has underpaid staff. So I would view that they would have, an intent to do the right thing and do have the resourcing there, and yet still somehow get that wrong. I'm not sure, Dr. Forsyth, if you perhaps had an answer to that or some thoughts on that you'd like to provide.
I think cases like the department and other organisations that have fallen foul of underpayment laws, I think what these show is that even organisations with the best intentions can get things wrong. And there's always some complexity in the interpretation of statutory provisions, the Fair Work Act, the terms of awards and enterprise agreements. But we would reject an overall excuse of it's just too complicated as the reason that many employers, underpay their staff. There are far fewer federal awards with much less detailed provisions than existed historically. And there are also many tools available to help businesses ensure they get it right, including software and IT systems and the advice they can obtain from industry associations and lawyers. And in terms of falling foul of the new criminal liability offence, part of the test for establishing that you've breached that provision goes to corporate culture. So a lot of that will be about what effort has the business made, what investment in systems and training and compliance tools has it undertaken in order to ensure that it's got the corporate culture right and therefore hasn't underpaid their staff.
Sure, thank you. And do you have any views on how regulations could be streamlined to make it easier for businesses to comply?
Well, I think generally streamlining historically has meant a reduction of regulation that, in our experience, has weakened worker protections. What we've seen in the response to wage theft over the last decade has been an incremental regulatory step-by-step attempt to deal with this problem through a mix of civil and now criminal liability provisions. The previous coalition government introduced changes to try and ensure that lead firms in franchising, for example, could be held accountable for underpayments that occurred within that supply chain. The Morrison government brought a bill forward to try and introduce criminal wage theft offences. That bill didn't pass. That was part of the post-COVID IR omnibus legislation. But it's only since the Albanese government has come into power that we've now seen the addition of criminal liability. We need to see how that works in practice, and a range of other measures, including the increasing in civil penalties and also the increase in the small claims procedure up to $100,000. So we would say those are all necessary responses to this problem, and that streamlining, as you talk about, in our experience generally, has not worked well for workers.
Sure. Your movement campaigned for the criminal offence, and across the union movement, or more specifically what the ACTU has seen. Can you point to a specific change in behaviour that you can clearly attribute to the Section 327A changes?
No, not at this stage, because there's insufficient evidence to point to any such direct effect of the laws.
Okay.
It is one of the reasons why we say a wholesale review of the work of the Ombudsman, the mix of civil and criminal regulatory consequences for underpayment, and the mix of who is the appropriate regulator, or what specific enforcement functions should be given to which regulator. Senator Payman has talked about the amount of money that's been allocated to the Ombudsman specifically to operationalise this new criminal wage theft offence. We have a Fair Work Commission at the moment that is subject to a very heavy and growing caseload. And when we talk about perhaps adding to its caseload by giving it a role here, I think what we're saying is let's look at this in a wholesale, holistic fashion, look at all the different laws in place, look at the different regulators, and see if we can come up with the best mix of approaches.
Thank you. And thank you both organisations for your evidence today. If you've taken any questions on notice, if you could please return the answers to the Secretariat by Monday, the 18th of May 2026. We will now suspend for a brief break and we will resume at 12:15 p.m. Thank you. representatives from the Australian Chamber of Commerce and Industry and the Migrant Workers Centre via video conference. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you each please state your full names and the capacity in which you appear today? If Aki wants to go first.
Good morning, Senators. My name is Sean Schmidtke. I'm the Head of Workplace Relations Policy at the Australian Chamber of Commerce and Industry.
Thank you.
Hello, Senators. My name is Matt Kunkel and I am the CEO of the Migrant Workers Centre.
Thank you. I now invite you each to make a short opening statement, and at the conclusion of any remarks, I'll ask members of the committee to ask questions. Thank you.
I'll go first. Thanks very much, Senators, for the opportunity for the Australian Chamber of Commerce and Industry to appear today and to assist the committee with this inquiry. As our written submission notes, at this time we say there is insufficient evidence and data to enable any meaningful conclusions to be drawn as to whether the new provisions under Section 327A, subclause 1, are working as intended. In saying this, we should also stress that in many respects, the extent to which the new provisions are effective or otherwise will always be something that's very difficult to reliably determine, given they are focused on deterring behaviour involving intentional wrongdoing. To that end, the absence of prosecutions or data to date in the context of this inquiry, we say can only lead the committee to draw one of two conclusions. They are either A, that the new provisions are in fact working as intended, in that they are in fact operating to deter behaviour involving intentional wrongdoing, or secondly, the new provisions were created as a result of commentary about intentional wrongdoing, which has turned out to be overblown and necessarily hyped, suggesting that the changes were rushed and represent a solution to a problem that doesn't exist, to the extent that it was said to justify them being included as changes to the Fair Work Act. And in fact, it is a position of ACCI that the latter conclusion should be the one adopted by this committee, and we respectfully recommend that it find as such. Very briefly, I just would like to make a few other quick points. First, the committee should seriously question the decision of government to allocate significant resources in terms of financial appropriations and personnel resources to this issue, and whether or not this represents genuine value for money to the Australian taxpayer. Secondly, the absence of prosecutions to date should not lead this committee to make any recommendations or findings to the effect that the quote bar is too high, as some submissions to the inquiry has suggested. Thirdly, we also note that the new provisions act to capture late payments, meaning that a payment made late on a one-off basis technically can be considered a criminal act. It's ACCI's view that the provisions, if they are to remain, should be focused on conduct that seeks to intentionally and permanently deprive somebody of the payment to which they are entitled, not merely a late payment. Fourth, the committee should have regard to the increasingly complex, confusing and unwieldy nature of the Fair Work system and the significant difficulties this creates for business, particularly small business, to achieve and maintain compliance with the law. And lastly, we say that the use of nomenclature such as wage theft is an unhelpful term. The legislation itself does not refer to or use these words. It is couched in the context of intentional underpayment. We say the use of wage theft is a cause of significant and unnecessary confusion. Happy to take any questions or speak further to any of the points I've raised.
Thank you. Migrant Workers Centre, do you have a brief opening statement?
Yes, Chair. Thank you. Very briefly. The Migrant Workers Centre operates in Victoria to educate migrant workers about their rights and supports them to enforce those workplace rights. And we welcome the opportunity to come and talk to you today. Having listened to the previous session, I'd like to start by supporting the comments that Dr. Forsyth made in his opening statements for the ACTU, particularly those around the difficulty in judging whether these measures have had enough time to flow through into the community. We know from our work that wage theft remains a pervasive issue in the nation's industrial landscape. And while the Migrant Workers Centre welcomes the government's efforts so far to combat this form of exploitation, there will always be more to be done in this space. In particular, migrant workers face additional barriers, including the availability of in-language materials about their rights and in accessing justice when those rights have been ignored or breached. There also remains some cohorts of migrant workers who remain wary to engage directly with regulators, which will necessitate a multi-pronged approach, including unions, community organisations, and other worker advocates. We've made submissions to another current inquiry examining the NES about improving the information provided to workers at the beginning of their employment. Specifically, rather than simply providing the template Fair Work information statement, which includes generic baseline information on rights and where to get help, we submit that employers should provide a more fulsome statement outlining the new employee's relevant pay and conditions, demonstrating that they have considered their legal obligations to the employee, and that this statement should be provided periodically through employment as their conditions may change. Requiring employers to take this active step to consider the appropriate industrial instrument and the classification at the point of employment may also provide an important evidentiary basis to determine the level of care and attention employers have paid to meeting their obligations under the Act, and that in particular when regulators may be looking to build a case for prosecution. The Centre operates at the intersection of both our industrial and migration systems, and there are some difficulties faced by migrant workers, particularly those who remain reliant on sponsorship by their employer to remain in the country. And while there have been some significant and very welcome changes through the Strengthening Employer Compliance Bill, many workers still face a very difficult choice to report exploitation due to concerns about disrupting their settlement pathways. Many employer, all those on visas sponsored by their employer are reliant on their employer not just for their wages but their residency rights. And in many such cases, workers are making the economically rational choice to preference their ability to stay in Australia over recovering what is owed to them in stolen wages and entitlements. So improving worker protections under the Migration Act can and will give migrant workers more confidence to raise issues of wage theft, which will have a positive effect on everybody who works in Australia. Thank you.
Thank you so much. My first few questions are to ACCI. What are the major cause of underpayments amongst your members?
Thanks, Senator. The major causes seem to be the complexity of the Fair Work system generally, and specifically the interpretation of various industrial awards and various provisions contained within those awards. I was listening earlier and I heard, I think it was ASIO talk about public holidays and understanding what entitlements are required to be paid on public holidays. I would agree with those comments, but I think it's just a general, because we do have a very broad membership, I suppose, across a vast number of sectors. I think it is a general concern about the interpretation of industrial instruments and certain provisions within those instruments. We saw that recent case involving, I think it was Woolworths and Coles, relating to annualised payments to employees. That was a federal court case. It was an extraordinarily complex matter, and it's involved a reinterpretation, perhaps, of how annualised salaries are paid in Australia. So that's an example of where a significant underpayment has arisen as a result of an interpretation of what was quite a narrow elements of a particular industrial instrument. Its interpretation by a court has resulted in, obviously, a significant amount of underpayments being made, but that's an example of the types of confusion that arise. I'd also say that there is I suppose, a general increase in the level of regulation that business has to deal with, particularly small business. If I'm to look at, for example, the General Retail Award, that's 70 pages long now. When I first started in industrial relations, the New South Wales version of that award was, I think, 35 pages long. So there's an increase in the sort of complexity of those instruments and the way that those instruments are interpreted and applied. There's probably much more I can say on this point, but I might just leave my comments there.
Thank you. And my concern is the suggestion that, employers are just rampantly stealing from their employees, particularly small business operators who, in my experience and having run my own small businesses, we're well connected to our employees and want for the business to do well. The employees have to also do well and be happy and stay there. So I just want to get an understanding that that's not what you're seeing, and that's not the insights that you're getting from your members, that there's this, concerted cultural campaign of paying as little as possible, which is, I think, the evidence from one of the union officials earlier.
Yes, Senator, I can confirm that is not what we are seeing. As you rightly say, the feedback we have from small business owners is that they want to do the right thing by their staff. They try to do the right thing by their staff. And in fact, ensuring that they do the right thing by their staff is essential, particularly right now in the context of where the labour market sits. I walk past 5 or 6 cafes every morning on the way to work with help wanted signs that have been there for quite some time. A lot of employers, particularly small business employers, are desperate to get staff. And to that end, if they do get staff, they go out of their way to hang on to them. So certainly that culture of deliberately underpaying people as a business model, as has been suggested, is not something we're observing.
Sure. And should, in your view, the wage theft criminal element be restricted to deliberate or knowing conduct? And why, in your view, does the current fault element risk prosecuting mistakes? And what does that do then? What are the economic impacts, perhaps, of that, and the more broader social impacts to small businesses?
Yes. So the existing, and I'm just bringing it up as we speak, the way that the existing offence is structured is that a potential criminal offence can occur if an employer is required to pay an amount on behalf of, to, or for the benefit of an employee, and the employer then engages in conduct, and that conduct results in a failure to pay the required amount to an employee on behalf of, or for the benefit of the employee, in full on or before the date when the required amount is due for payment. Now, that's a fairly broadly expressed provision, and it certainly suggests that somebody should know what the amount is to be paid to an employee, and they engage in conduct deliberately to not pay that employee. So if I know, for example, I'm required to pay an employee $20 an hour, I've got advice to that effect, very clear from the award, and I instead decide to pay that employee $12 or $15 an hour, knowing that that is the wrong thing to do, that's the type of thing that can be captured by the offence. However, it's also structured in a way which says that the payment has to be made on or before a due date. So if the payroll cycle says that the employee gets paid weekly, and for whatever reason an employer is prevented from paying that employee on that particular day, whether it's a payroll issue, whether there's some problem with the business and it's they happen to have a power cut or something like that, if they're a day late, technically that can trigger the wage or the criminal offence under section 327A1. Now, that is a concern to a lot of employers, and what's the impact of that is that a lot of employers have this heavy cloud hanging over their head that one potential late payment could result in them suffering penalties of up to over $8 million or potentially 10 years in jail just for paying somebody a day late. Now, I'm not suggesting necessarily, I'm sure the FLO will tell you later today that that's not the intention to capture that conduct, but that's the way the legislation is written at the moment, and that's the concern we have with it. Now, a lot of small businesses go to work every day. There's a range of compliance obligations they have, whether it's work health and safety, discrimination, workplace laws, industry-specific laws in a lot of sectors. There's a huge range of compliance burden that exists. This particular additional element is a cloud that sort of hangs over their head on a daily basis. And the way that the offence is currently structured, we think that's unwarranted.
Sure. And what's your view on how we fix this? Like, what's the solution to addressing, like, the example that you just raised of, being a day late for, things out of your control entirely? In the current framework, like, how do we make it simpler for businesses to actually do the right thing?
Yeah, good question, Senator. So there's 2 elements to it. I think either one, there should be some sort of time frame if an employee is not paid within a particular point in time, or number 2, there should be an element in the offence that requires there to be an intention of the employer to permanently I suppose, deprive the employee of that benefit and take something away from them, as opposed to delaying it for reasons beyond the employer's control.
Sure, thank you. And to the Migrant Workers Centre, in your experience helping migrant workers recover unpaid wages, what makes the biggest practical difference for the workers you assist? Is it better resourcing of the Fair Work Ombudsman, simpler pathways to recovery, or the introduction of criminal penalties? What do you think would make it simpler and easier for the workers that come to you for help?
I think it's a matter of trying to improve all aspects of those things, not just perhaps saying one thing makes the major difference. Critically for us, we have seen...
I get that it's all of them, but is there a biggest practical, like if we sort of went, where could we put our focus, what would that best practical first step be?
Well, we would say the best practical step to support the workers that we work alongside of is to give them the confidence that raising issues about workplace exploitation will not have detrimental effects on their ability to continue to stay and work in Australia. Many workers in this country have been so-called temporary for many, many years and have spent many thousands of dollars building a life and building a pathway to settlement. And the idea of pursuing a wage underpayment claim or a superannuation underpayment claim of $10,000 to $15,000, for example, might not be the economically rational decision because they've spent more than that studying, working, building their lives here. So we would say that improving whistleblower protections, improving settlement pathways more broadly would be the biggest thing that the Parliament could do to improve the ability and the willingness of migrant workers to raise these issues and pursue justice.
Thank you so much. Senator Payman, you have the call.
Thank you, Chair. Good morning to you both. My first question is to the Migrant Worker Centre. The Australian Nursing and Midwifery Federation submitted that the government should consider, in addition to the existing offence, an aggravated offence which would result in harsher penalties where it is determined that a victim of wage theft was exploited as a result of a vulnerability, which could be lack of English language proficiency, migrant status, age, disability, or similar characteristics. Now, notwithstanding the fact that the existing offence hasn't been used yet, would such an aggravated offence be helpful in discouraging exploitation of Australian workers born overseas, in your opinion?
It's not something that we've considered, Senator. Thank you for the question. And it's something that would ultimately depend on the final framework of how that was built. But I think the ANMF have made some good points about that. And there are obvious intersections between people's specific the nature of the worker themselves about their vulnerability to wage theft and other exploitation. So making sure that people are cognizant and employers are cognizant of that and take extra care with those workers is an important thing. But again, key to that, we say one of the very ultimate vulnerabilities of many migrant workers is their temporary visa and their unwillingness to kind of jeopardise some of those pathways.
Yeah, thank you. And just to ACCI, on the safe harbour provisions, does ACCI have any data on how many businesses have made disclosures under these provisions and, you know, what happened as a result of those disclosures? Because I'm particularly interested in what the Fair Work Ombudsman submitted around the safe harbour provisions where it only protects businesses from criminal prosecution and that the Ombudsman can still take civil enforcement against them. If a business comes forward voluntarily to disclose underpayments, but the disclosure can then be used to pursue civil action against them, does ACCI think this reduces the likelihood that businesses will use the safe harbour provisions in the first place?
Thank you, Senator. That's an excellent question. And to answer it, we don't have any data on that specific question. And I could only refer you back to what the Fair Work Ombudsman has said. Of course, I think there is to some extent it's easy to anticipate that there will be some businesses who might be discouraged from using that safe harbour provision on the basis they're still exposed to serious contravention penalties, which could be up to over $4 million essentially. So there is that concern there, but I do think that a business where they discover an underpayment, they take steps generally in our experience to rectify that underpayment straight away. We will advise employer to go to the FOIA in the event that it is a significant underpayment. But if it is a small business and there's been an underpayment, we advise those employers to rectify it straight away, explain to the employees how it's occurred, explain to them what rectification is, and explain to them what steps are put in place to prevent that from occurring again.
Yeah, and just further on that, would you not see that as there being a further disincentive for a business that has identified wage theft as having occurred if the Fair Work Ombudsman does not agree to enter into a cooperation agreement, that it may become subject to criminal investigation under 327A, Section 327A1, and have incriminated itself when attempting to make a good faith disclosure?
Look, that's a difficult question to answer, Senator. I think at the end of the day, if an employer has engaged in intentional underpayment as prescribed or envisaged by Section 3271A1, then I'm not certain that that would be a relevant necessarily consideration for that business, and certainly not small business. Now, look, if it is a one-off late payment, the expectation would be, although technically the legislation doesn't say this, the FOIA will tell you that that's not necessarily going to result in a criminal prosecution. So I don't think it's necessarily a live issue in the context of small business. There is a capacity for the FOIA, obviously, to not enter into a cooperation agreement, and there's certain quite strict conditions around which those cooperation agreements are entered into. I think that's, in the context of small business, it's more a case that that cooperation agreement is aimed at larger businesses where there has been a significant scale of underpayment, rather than necessarily that at the small business level.
Yes, and I mean, to your point, the point you were making to the Chair's question earlier around the one-off late payments that may be made, but that could potentially result in being considered a criminal act. Now, we know that a criminal conviction for late payments would still require proof beyond reasonable doubt that the employer, deliberately intended not to pay the worker on time. So it would not capture, genuine mistakes or things beyond your control. Would you say that, do you believe employers should be able to deliberately, not accidentally, miss paydays and get away with it?
Well, I believe that an employer that intentionally or deliberately doesn't pay an employee on or before the date that that payment is due, if it occurs in circumstances where that's done knowingly and it's done for circumstances beyond the employer's control, I don't feel that they should be penalised. I don't think that any employer who deliberately decides to delay the payment to an employee for reasons other than something that's beyond their control, I don't think that should be is acceptable conduct, and that is likely to result in a civil prosecution potentially under the Act where that behaviour is occurring. But if it's beyond their control and it's a one-off, then I think that that should not result in any type of criminal prosecution or consideration.
Thank you. Thank you, Chair. I'll put the rest of the questions on notice, being mindful of time.
Thank you so much. I appreciate it. Senator Barbara Pocock.
Thanks, Chair, and thanks both of you for being here. Questions for each of you, but if I can start with you, Mr. Schmidtke, from the ACCI perspective, I just want your sense of how you see this problem. We've been given evidence from both the Melbourne Law School and the McKell Institute, which tells us that this is a large and growing problem. The underpayment of wages is really a very significant almost a normalised practice, especially for many young people. Their data is showing that a third of young people are underpaid, and Mikel also showing similar data. Given that it's so widespread in these particular pieces of research, the latest that we have available to us, does it not trouble you at ACCI that this is a systemic issue that is really disadvantaging your members who are doing the right thing?
Well, so the first thing is that I've not looked at those reports in detail, but I am aware of similar reports. And I suppose the question is the extent of whether this is an intentional decision to underpay people knowingly, or whether or not there is some other issue that arises that causes an underpayment to be made. And I think that's an important distinction. Secondly, I'm aware that those reports, to the extent that they refer a lot to young people, refer to things like the retail award, hospitality awards, and those type of awards, which are notoriously complex to achieve compliance with. I think under the general retail award, there's over 1,000 different types of permutations of pay that can be made in any 1 week under that particular award. So it's extraordinarily difficult to comply with. In terms of the question about whether or not this disadvantages our members who do the right thing, obviously, there is a concern that those people who do the wrong thing may potentially result in a situation where they can undercut those who are doing the right thing. However, I think that the extent to which this problem is stated in those reports doesn't necessarily go into and account for the fact that those underpayments are likely to be rectified at some point. If they're not being rectified, then the Fair Work Ombudsman should look at those reports and speak to the author of those reports and get out there and start prosecuting those people and those businesses and the employers that employ those people. When I see these reports of 1/3 of young people not being paid their wages each week, I automatically think this is an action for the FWO to pursue. They should be getting into those particular industries and those employers, finding out who the employers are and going through and engaging in audits. And I think that the FWO do that. I think they're very responsive in terms of identifying particular areas where there is non-payment or underpayment and then conducting audits and campaigns and things like that. So my view would be to the extent that it disadvantages our members who do the right thing, of course it always will, but at the end of the day, most of those underpayments should be rectified, and to the extent that they have not been, the FWO should be looking at them very, very seriously.
And what are your reflections on superannuation? As we have been sitting here, the Super Members Council today has come out with data saying that $24 billion has been lost to Australian workers between 2018 and 2023. And that's a very significant loss to anyone in retirement, especially young people, where this loss is particularly concentrated. What are your reflections about this issue of superannuation? Because it is a big and certainly looks like a growing problem.
Well, I would say, Senator, that number one, we need to take account of the forthcoming payday super legislation that the Parliament has passed. I think that's going to make a significant difference to the extent of this problem. I think those same figures have been used to agitate for and to justify the introduction of payday super laws. They are due to kick off on the 1st of July this year, and I think that will make a significant improvement in the extent to which this problem is dealt with and captured, first of all. And secondly, I think that we need to probably assess the impact of that legislation on the extent of underpayment involving superannuation. The third thing is that payment of superannuation, and I heard one of the witnesses earlier referring to when super was 10%, and he made, I think, a comment to the effect of, why can't you just work out 10% of somebody's wages to work out what the super contribution is? The reason for that, of course, is super is payable on ordinary time earnings. There are certain elements that are subject, as we all know, to superannuation and payments that are not. It is not always very clear as to how those particular payments should be treated for the purposes of SGC contribution. I think that that's an element as well.
Thanks for your evidence. If I can come to you, Mr. Kunkel, we've heard considerable evidence about vulnerable workers generally being especially vulnerable to underpayment, both of super and of wages. What particular steps would you like to see coming out of an inquiry like this that are going to help meet the problem that your evidence is relating to?
We would like to see some improvements to particularly the strengthening reporting protections that have been made available to migrant workers that will expand their accessibility to additional workers, particularly those that are engaged in the PALM scheme. Also the continuation of the workplace justice visa, which we say has been a successful introduction to the migration scheme that provides genuine access for some migrant workers who would have been denied the ability to bring cases against their employer to actually achieve justice. So those two, the continuation of those and improvement of those two measures would be key. And also, I think as the ACTU pointed out a little bit earlier, there are very lengthy periods of time to go from raising your claim to actually having it heard and settled. Anything that can expedite justice and workers being able to bring their cases through the courts would be very useful. But as I said at the top, improving the information that is given to workers about what they should be paid and what conditions they should expect, and providing that in a language that they understand, particularly for those where English is a second, third, or fourth language, would be key in making sure people understand their rights, because you can't enforce a right you don't understand or don't know you have.
Given that you heard the earlier evidence, what was your response? What's your view about the argument for a much more accessible? You're talking about information, that's kind of a front-end essential thing, but when you get the information, you recognise you've been underpaid in super or in direct wages. What's the case, or do you support the argument we've heard for an accessible small claims jurisdiction where registered organisations can also be of assistance to help things get into a more accessible, cheaper, more timely set of responses through that kind of jurisdiction?
This would need to be the final question, Senator Pocock.
Yes, we support that, Senator.
Okay. Short answer. Thank you. Thanks, Chair. Thanks for your evidence.
Thank you so much. Senator De Lager.
Thank you, Chair. Good morning, both. Thanks for coming along. Mr. Shriki, just wanted to start off with a question to ACCI. Going back to an article that the ABC published in 2020, it reported that the Fair Work Ombudsman found several 7-Eleven franchises had deliberately falsified records to disguise wage underpayments, and that 7-Eleven's approach to workplace matters did not detect or address deliberate non-compliance. Would ACCI acknowledge that incidents like this, where workers are having their wages stolen, are...
Oh, sorry, Senator. I just lost you the last few words of your question.
Oh, sorry. Would you acknowledge that where workers' wages are stolen, that it creates a problem?
Oh, thank you. Look, that 7-Eleven situation, I think, was an extraordinary situation. I think it's certainly not the norm. In fact, if anything, it's the exception. That was clearly a case where there had been a systematic, deliberate, knowing approach of conduct or pattern of conduct that was designed to systematically, as you say, using words, rip people off. That type of conduct, where it occurs, should be called out, and those who engage in that type of conduct should feel the full force of the law. Now, I understand that that particular conduct occurred at a time before the current laws were in place, but that still, on any viewing of it, represents theft, and there was no reason why those particular businesses or persons involved should not have been referred under the criminal code as then and as exists now for prosecution for theft.
I'm sorry, mate. I just missed out on the last couple of words there that you said.
Oh, sorry, Senator. I simply said that there's no reason why those involved should not have been referred under the criminal code and the laws that existed at that time, which were capable of punishing them for engaging in what was theft.
Thank you. ACCI CEO, Mr. McKellar, Andrew McKellar, recently made a comment to a Conservative media outlet regarding this inquiry that the only instance of theft that we can find is the robbery of taxpayers' dollars. Given given that we've had submissions from regulators and researchers that points to the problem of wage theft, does ACCI believe that there are no instances of wage theft based on those comments?
All I can say, Senator, is that the evidence from the Fair Work Ombudsman is that there have been no prosecutions brought under this provision 327A subsection 1 of the Fair Work Act, and that in the period of operation since the legislation has been effective, which is I think 1st January 2025, there has been no referrals made by the Fair Work Ombudsman to either the AFP or the CDDP for prosecution under that particular provision. If the, as I said at the start, if the nature of the problem was such that was represented during the debate on this particular bill to introduce this offence into the Fair Work Act, then there would surely have been more prosecutions made. Either the legislation is working as intended in that it's deterring people from engaging in this intentional misconduct, or the problem was overstated. Now, we prefer the latter. And to that end, we do think that you could probably find better ways for the Commonwealth to spend $50 million and better ways for the FWO to deploy the expertise of 16.7 people currently employed in that particular section.
And when it comes to speaking of deterrence, the Dewar submission notes that these laws were created after careful consultation with stakeholders to only capture employers who deliberately underpay their workers. So would you acknowledge, or would ACCI acknowledge that that there should be a strong deterrent in place to deter people who might want to, or deter businesses who might want to deliberately steal from workers?
There needs to always, Senator, be a deterrent in place of some type. There are already, and I think successive governments have increased the maximum penalties and created serious contravention penalties, or a class of penalty under the Fair Work Act, which, as I said before, I think is punishable by, I think up to, I'm just looking at now, $4.95 million in penalties. Now, I think that is a very significant deterrent, and I think that the deterrence and the level of deterrent under both serious contraventions and the various other compliance obligations that exist under the Act and the potential penalties that arise are significant enough to act as a significant deterrent. If I was a small business owner, having the penalty of almost $5 million hanging over my head, to me would be a massive incentive to make sure that I pay my people and I get it right.
Thank you, and I think everyone acknowledges that small businesses that do mostly do the right thing as well, and they want to do the right thing by their employees. I just want to put a scenario to you based on one of your responses. I think it was to the chair earlier on about things happening when when a business might pay a worker late due to a maladministration and not maladministration, just due to an administrative or a non-deliberate mechanism, something beyond their control. Let's just say, so a business might underpay, not pay the worker till a day or two late because of an error that may have occurred. What under the current laws might happen based on that scenario, where it's a non-deliberate offence?
Yeah, well, under the current law, if the Fair Work Ombudsman was involved, I've got no doubt that they would apply their usual compliance and enforcement policy to a payment like that.
And so they would consider whether or not it was a deliberate.
They would. I think in the first instance, the FWO would consider whether or not the regardless of how the issue occurred, they will want to make sure it's rectified. So they would pursue that approach of voluntary compliance, then they'd pursue an approach of guided compliance, and then enforce compliance in the event that that didn't work.
But you say the employer just paid the employee a day or two later.
This will have to be the final question, Senator Delaga. Thank you.
Yeah, absolutely. Yep. They paid them a day or two later. The Fair Work Ombudsman would more than likely look and say, this is not a deliberate issue, pay them in the future. That would be fairly likely, just from pay on time. Now,
yeah, potentially that's right. Potentially that's right. I mean, I don't want to necessarily go into a hypothetical about the
of course, yes,
may or may not do. But if this was part of a pattern of behaviour, the FRO may well.
No, where there's no pattern of behaviour, just a worker being paid late. Yep. So then the flow-on effect, if that worker is paid late, they then go into Woolies and they're a parent. They say, oh, sorry, Mr. Woolworth, I can't pay for my groceries today. I'm going to just take these groceries, but I have every intention of paying for those groceries tomorrow. What do you think would then happen to that particular worker? The cops would probably get called, right? And they'd probably get taken away and probably get charged.
I don't want to engage in hypothetical, Senator, but I would suggest to you that if there was if that situation had happened, the employer would know that the employee would know that the employer had not paid because it was a circumstance beyond their control. A sensible employer would say and advise the employees, we've been unable to pay you for the following reasons, and beyond our control, we will make that payment as soon as possible. A reasonable employer would likely also take some other step to inquire as to whether or not this would provide some sort of immediate hardship to an employee, and again take steps to rectify it. But an employee would also likely know that they haven't been paid because their employer's told them it's going to be a day late, so they probably wouldn't go into the supermarket and try and spend money.
But saying what I'm trying to ask you is if a person or a worker went into Woolworths and said, I'm going to pay you my groceries tomorrow, and took them, they would probably get charged and taken away because they have essentially stolen from that supermarket. However, an employer organisation might pay the day later, and they'll have still rectified and get away and be perfectly, next time they'll pay fine and they'll nothing would essentially happen. So do you think that under the current laws as they are currently written, that who has more power still under this here? It is employers, or do you think the workers would be punished more under the current laws?
Senator Delaga, that will really need to be the last question. Yep. Thank you.
Look, and Senator, I know the point you're seeking to make here. I do think it is a hypothetical and perhaps a very unlikely hypothetical. I'd simply say that in both cases, and should say no more than this, in both cases, regulators or people charged with enforcing the law would take an appropriate approach to ensuring whether or not the law has been actually breached to such an extent that it would require a charge or penalty in a criminal prosecution being lodged. Police take a very sensible approach to these things. Store owners take a sensible approach to these things. The Fair Work Ombudsman takes a very sensible approach to these things. I don't see how it would change in any circumstance.
Thank you. I might take that the laws are not skewed in the workers' favour still. So thank you for your evidence today.
Thank you for your evidence today. If you've taken any questions on notice, if you could please return the answers to the Secretariat by Monday, the 18th of May 2026. We will now suspend for lunch and resume at 2 p.m. Thank you. Welcome Dr. Kate Smithers and Associate Professor Jess Harris via video conference. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to each of you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Hi, I am Jessica Harris. I am an Associate Professor in the School of Education at the University of Newcastle.
I'm Kathleen Smithers and I'm from UNSW in Sydney.
I will now invite each of you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions. Dr. Smithers, if you would like to go first.
We have a combined statement, if I may.
Oh, wonderful. Go for it. Thank you.
So we are two academics who have undertaken research in higher education, policy and management together since 2019. I've been working in this field for about 10 years and publishing on research, particularly around casualisation in higher education with Kate since 2019. We have published as well on higher education governance and policy more broadly. Of particular interest to us is the concept of wage theft. Over the past decade in Australian universities, according to the NTEU, universities have been found to engage in wage theft, totalling over $311 million so far. And this figure doesn't include underpayments from universities that have engaged in their own audits. We acknowledge that compared to other industries, including those that are represented here today, academic staff are generally considered to be incredibly privileged. There are high expectations of high levels of education and expertise within the field, and it is a highly competitive industry with extreme levels of casualisation relative to other sectors. Many of these casual and fixed-term staff, and in our experience, even permanent staff, are reticent to speak out about their working conditions due to fears of lost work or penalties from their institutions. In 2022, we published an article about precariously employed academics who undertake substantial unpaid work. All of the interviewed academics reported working well beyond their paid hours to position themselves as competitive in the academic job market, to complete the administrative requirements of their roles, and to provide high-quality teaching and research. The overwork and underpayment of academic staff, particularly casual staff, is an enduring theme in our research.
In 2025, we undertook a survey of academic staff across Australian universities and received over 500 responses from a range of university staff. In our data from this project, there are multiple instances of what could be called wage theft. People reported conducting substantial unpaid work, working during annual leave to complete requirements from their university, being assigned hours for teaching and learning rather than being paid the time it takes, and having their teaching reclassified as workshops or labs to reduce time allocated to their teaching, and then being paid as a demonstrator rather than an educator. And we also had reports of managers falsifying workload calculations to obscure the amount of time an academic had worked each week. We note that the data collection for this started in May 2025, after the criminal offence for wage theft came into effect on the 1st of January 2025. We identify in our submission that one problem with higher education as a sector is a culture of overwork and obscured workloads. This sector relies heavily on staff commitment to high-quality teaching and research, while requiring them to increasingly do more with less. These systematic issues disproportionately impact the most vulnerable staff, particularly casual staff and early career academics, who are often the most impacted by wage theft. To address the central question of this inquiry, it is clear there are instances of wage theft occurring, but in a sector like higher education, these cases can be complex and occur through diffuse institutional practices. While the concept of intentionality is important within investigations of wage theft, until we rectify systemic structures that encourage underpayment, these practices will continue. Thank you.
Thank you. Senator Payman, you have the call.
Thank you, Chair. Good afternoon. to you both. Thank you so much for your submission and appearing before the committee. Now, you note in your submission the difficulty of proving criminal wage theft in sectors where underpayment arises through diffuse and institutionalised practices rather than clearly identifiable and deliberate acts. Now, through things like marking assignments and preparing material, the idea that higher education workers are often required to extensive unpaid work has become normalised. Do higher education workers have any say in this, or is the decision for workers as simple as do the unpaid labour or get the sack?
I think across universities, most universities in the country have a set number of hours that they will allow any casual academic to work, which is generally 1 hour per student per semester over a 12-week semester in most instances. And that involves all of the administration, the marking of assignments. There have been reports that that means for many academics, they're allocated about 10 minutes to mark a higher education assignment, which they feel obviously is not sufficient to provide detailed feedback and the sort of supports that students need. There is definitely fear about speaking out against that, because unless you're producing high quality work, somebody else will come along and take the job.
Yeah, no, absolutely. And just on promotion policies, I had a quick look at the paper Dr. Smithers and Professor Heffernan put out on promotion policies. It notes that some promotion policies were hidden behind a firewall and that you were unable to obtain policies for University of Western Australia and Murdoch University. Now, being a senator for WA, I'd be interested to learn about promotion policies at WA's universities like UWA, Curtin and Murdoch. So firstly, I'm curious to understand, were UWA or Murdoch's policies behind a firewall, or were they just not published at all?
Thank you for the question. They would be published behind a firewall of that university. We did note when we were doing the data collection for it that it did seem interesting that most of the Western Australia ones were behind a firewall. That data collection was in 2024, and so that was a little while ago for me now. But from my memory, I have a feeling that there was something to do with it being a state-based enterprise agreement, or something to do with Western Australia specifically having its own set of requirements around that. But again, I'm really sorry, it was 2024. So I could look into that for you and let you know. But
yes,
they were
please.
definitely behind a firewall.
Yep, no, absolutely. I'm just really curious to understand what information about promotion policies you can provide to the committee of WA University. So you can definitely take that on notice. Now, do you have any information on what experiences higher education workers have had when going through going to Fair Work about things like promotion policies and the culture of unpaid labour?
We've heard a whole range of experiences. Mostly the experiences that we have heard, though, are people who are too reticent to speak out. So we have participants in our data who have worked through cancer treatments, who have continued working through major life upheavals and not wanting to disclose any challenges that they're facing due to the potential for them to lose work.
And what do you hope that an inquiry into wage theft, what outcome would you be hoping that this inquiry would have?
Thank you. I think we would really value some more inquiry into the systematic structures that have grown through the university sector, the high levels of casualisation within the sector, which were reaching up to 70% of the workforce before the Closing the Loopholes Act. We haven't got very clear understanding because universities report on full-time equivalency rather than individuals, and the research shows that a full-time equivalent position could represent up to 12 to 16 different workers. So those issues are quite widespread, and the review of these promotion policies that require academics to be working at the level above their paid, their current paid level of employment for 2 years before they are eligible for promotion.
Yeah, no, definitely hear you on that. Now, you've made a point that the offence is relatively new, the criminal wage theft offence. Do you believe that the existence of this offence will be of any use to workers in higher education in the medium to long term?
We aren't confident that it will be. As you noted in our submission, we do think that there is a way of operating in higher education that means that intentionality would be quite hard to prove, particularly as there are layers and layers of administration that do end up obscuring what is actually occurring. And I think it would be hard to pinpoint in one way or another somebody's intent to underpay their staff. Beyond the promotion policies are probably a really explicit example of that, as it is written into policy that these are the requirements of academics to be promoted. But for casual staff, a lot of this happens in conversations and in ways that aren't documented. Even if a university does have payroll systems that account for overtime, these are often, there are practices that mean that these aren't used in the way they could be. And even in our data from our most recent survey, we have examples of managers changing workload systems to make it look as if staff are working less, and people being required to work more than the hours in the enterprise bargaining agreements for teaching and things like that, but it's being obscured by people doctoring the systems or even relying on staff doing things for free outside of hours. And it's a kind of coercive control in a way that there's no one person putting the requirement out there that you work for free, but it's still occurring.
Thank you so much for the evidence you've provided so far. I really appreciate you guys. Thank you. Thank you, Chair.
Thank you so much. Senator Barbara Pocock.
Thank you, Chair, and thanks both of you for your research and for your presence here today. I just want to pick up on the fact that probably of all industry sectors in the country, the university sector has had the most cases and probably discussion as a place of wage theft. What's moved? What's changed as a consequence? You've just mentioned some adaptive behaviours that are protective of the institution, but what else can you talk about? And I guess I'm not looking for a Pollyanna story, but I want to know whether all of that public discussion has actually moved things in these huge institutions, but mostly publicly funded.
Thank you for that question. The initial reports of wage theft that we were looking at were coming out just after the COVID period, which was a particularly difficult period for the higher education sector, having been locked out of the job seeker arrangements, meaning that academics, casual academics, were unpaid and unable to work in that period. Having looked across universities with our survey, which had over 500 responses, I can honestly say that not a lot has changed. Despite the closing the loopholes, we still have many casual academics who are employed and have their employment restructured, so they're now delivering labs rather than tutorials. And the difference that makes is that you don't get the same level of preparation time built in. You're just intended to be there for the hours that you are face-to-face with students rather than preparing for those lessons. We have also seen increasing precarity within the higher education institution more broadly, with job losses from permanent staff members. So while we'd love to say that we've seen changes, our survey has certainly told a different story.
So is it fair to say there have been responses within the sector but they have been around adaptation to prevent the appearance or traceable wage theft? Has that been the kind of shift to accommodate? Because has there been an embarrassment effect, I'm also asking, which has pushed, but the adaptation has been mostly in the effective concealment of unpaid labour. Is that correct?
I think the adaptations that have been made have been more university self-reporting and self-auditing, and that's been wonderful in that it's repaid staff who have been underpaid in the past, but there doesn't seem to be an overwhelming change in practice across the sector.
So can you say a little more then about the relationship between a punishment, a public calling out, and deterrence? Where do you land on that relationship, given your research? Can you say a bit more about that?
About deterrence, the difference between...
About how public revelation, including self-reporting of underpayment, acts as a deterrent or fails to act as a deterrent.
I believe that there hasn't been any real consequence for those institutions who have self-reported when they have rectified the underpayments. That has been reported by the NTEU, but hasn't seemed to impact on practices. There have been cases, however, where a lot of the responsibility for the administrative functions of overseeing casual staff particularly have been devolved to the individual academic. So as Kate was pointing out, it becomes a very diffuse system where individuals become responsible as the employer for their casual staff, despite working in a highly regulated system.
So although union density has declined in the higher education sector, it still remains, compared to many other places, relatively robust with delegate structures and so on. What are your reflections on other industry sectors where there isn't, that union awareness or a cop on the beat, as the SDA referred to it earlier? What's your reflections on what might be going on where that presence is not there?
My main expertise is in the higher education sector, so I wouldn't want to comment too much on other sectors.
Okay, and do you have any reflections on the recommendations from others, ACTU and the SDA, on the need for a more accessible form of recovery for individual workers, like a small claims jurisdiction? Have you given that any thought?
I would say we have thought not specifically about that recommendation, but about ways that this could be fixed. And without knowing the full details of that, I would say that there are a lot of problems in higher education with wage theft because people are afraid to speak out. And I'm not sure how you rectify that in any way when people are afraid that if they speak out about their work being changed to labs or from labs, that academic won't hire them again next semester. So I'm not really sure, beyond probably decasualising the sector a lot more than what's already occurring, because that's the problem. One of the problems in higher education is that you're not necessarily a casual worker in the same way you might be in retail. It's very piecework related, although it's technically you're still a casual employee. You're assigned piecework, and so there are more explicit ways of people holding pressure over you, I think. Although a retail employee might not get shifts and things like that, it's much easier to just stop giving someone work in the higher education sector.
Last question. You talked about the threshold, the evidentiary threshold for showing intention I want to make sure I've understood your argument there clearly. Are you saying that kind of chain of command in universities is so complex and diffuse that establishing intention is really difficult when it's essentially structural in nature? Is that what you're saying?
Thank you, Senator. Yes, while we understand that there are many other sectors that have that level of complexity, even the permanently employed academics who may be employing casual staff are highly restricted in what they're able to offer. They're working on either research funding, or they're working within the university guidelines, which state that they only have particular allocated times for marking, that you can't have additional meetings with casual staff that are paid. So there are restrictions within the sector, within the institutions, that make it incredibly difficult for managers or academics who really do want to do the right thing.
Okay, thank you. Thanks, Chair, and thanks so much for your evidence.
Thank you. Senator De Jager, you have the call. You're still on mute, Senator De Jager. Apologies. We still don't have you. Can anyone else hear Senator De Jager? No, we can't hear you. Shall I proceed and maybe you try and fix the issue? Thank you. Just a few questions from me. The government passed the Criminal Wage Theft Offence, Section 327A of the First Work Act, and it commenced on the 1st of January last year. To your knowledge, has any university been investigated under that framework?
Not to our knowledge.
Okay.
But there might be a case happening, but not to our knowledge.
Sure. And would you have an awareness of what has happened in the sector since? Have universities sort of changed their enterprise agreements? Have they changed their payroll systems? Have they changed employment practices specifically because of the introduction of Section 327A?
While every institution is different, we haven't seen any cross-sectoral changes, although there have been changes within institutions in payroll systems. A lot of the changes that we have seen in the last couple of years, however, have been a result of the Closing the Loopholes Act.
Sure. Your recommendations to the governance inquiry focused on governance reforms and consultation as the means to ensure better recognition and remuneration of work in universities. Reflecting on those recommendations, they didn't include any criminal sanctions as sort of being a lever to sort of solve those problems. Was that something that was sort of that you guys considered? Was that a deliberate choice? And do you think that Section 327A has limited application in your sector? I'd be interested to sort of get your thoughts on, the problems or perhaps some unintended consequences or the challenges.
I would say that it's not that it has limited applicability in our sector. I just think that it is one of those things that is so wound up in various things. To use that demonstrator example, part of the way that work is assigned is that in the enterprise bargaining agreement, which is agreed with the union, there is an allocation of time and money per lab or tutorial or whatever piece of work that is. And then at the local level within the university, there might be a staff member who is responsible for assigning workload allocations. And so they might assign one tutorial to a casual worker, or they might assign one lab. And that definition is often established within the school workload policy or the area workload or discipline workload policy, which sometimes is a committee of academics or a random or like an assortment of people within that school, or it might be a university-wide policy. And so I think that when you have the EBA governing one set of ways that the payment is made or the decision or the allocation is made, and then another set of local policies that sometimes are at the basis of one person, say a admin staff member or an academic who's responsible for allocating that at the kind of behest of the workload committee. How do you begin then to decide who is responsible for that underpayment? Is it the person responsible for the university workload committee? Is it the head of the workload committee? Is it the individual academic assigning that? Or is it the person who signs off that person's timesheet? I think that there is a range of different ways that the allocation of work at multiple levels is given in universities, which makes the application of this subsection harder. And I think, again, it makes it harder to kind of say there was intent of underpayment when there are so many ways that these different parts and different policies could be misinterpreted or reinterpreted or interpreted in 5 different ways depending on how the person is reading it. Oh, I think you're muted. Sorry.
Yeah, people interpret different elements in different ways, and that's how we have these issues. And I guess that leads to my last question is, do you think the complexity of our IR system actually increases the risk of employers making unintentional underpayment errors? And that may then be labelled as wage theft, even though there was never that intention to do that.
I think that is certainly a risk. Within the university sector, though, there have been statements in numerous inquiries showing that wage theft or underpayment has been built in as a business model within universities, that being able to employ the greatest number of casuals for the lowest rates that they can is one way that universities are dealing with the funding implications or the financial settings and contexts in which they're working.
So if it were less complex, do you think it would be harder for them to do that if that is in fact the case?
I think if there was some less localized understanding of how long particularly academic work, teaching work takes, and allocation of hours on the basis of time rather than on the basis of a predetermined algorithm that has been or workload models that have been developed from one level and just filter through the universities. I think that could be of assistance.
Yeah, I'm wondering whether the complexity is a useful shield for some.
Yes, I believe so.
Thank you. Senator DeLago, you have the call.
Thanks very much. Can you hear me now, Chair? Excellent, thank you. Thanks for joining us today. I just have a couple of quick questions. Just wanted to put on the record following the research and the stakeholders that you've engaged with. Do you support Labor's laws to criminalise wage theft? As my first question.
Thank you for the question. Yes, we would support certainly the investigation of wage theft across sectors. Yes.
And from your evidence that to my colleagues earlier, you were talking about wage theft being higher with insecure workers in the education sector. What other groups are most likely to experience wage theft from your research?
What we have found is anyone on casual employment, fixed-term employment, although there are reports from permanently employed academics that the workload that they are assigned within the institutions is impossible to fit into a traditional 38-hour week.
And obviously, following these laws, what do you think is the message that they send to employers?
I'm not sure if we can necessarily comment on the message that they send to employers. Our research did mostly focus on academic staff. We did have some senior leaders in our data, but most of it would be people who are not in senior management.
Would you think? Do you agree that they are a strong deterrent against wage theft?
I think it's hard to tell at this stage, given that there haven't been, to our knowledge, any investigations at this stage in higher education. I think it's hard to say. It's still too early.
And there's been a lot of talk about how these laws may capture businesses who are trying to do the right thing or will threaten their business viability. What would you say to that?
I think the higher education sector does have vulnerabilities in terms of funding and funding instability. We've seen that, especially. I think there's a inquiry about the job ready graduates reform at this moment, where there's a lot of discussion about funding, and so I think that universities can use that as a rationale, But I think that at the end of the day, as Jess already noted, the underpayment of staff is baked into the higher education sector, whether it's because of funding instability or other reasons. It is there, and I think that it's something that is at this time not due to funding discrepancies. It is because of the system and the way the system is structured currently.
Thank you. All right, that's it for me, Chair. Thank you.
Thank you so much. Thank you for your evidence today. If you've taken any questions on notice, if you could please return the answers to the Secretariat by Monday, the 18th of May, 2026. I now welcome Associate Professor Tess Hardy from the Centre for Employment and Labour Relations Law via video conference. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please each state your full names and the capacity in which you appear today?
Yes, thanks very much, Chair. My name is Associate Professor Tess Hardy. I'm appearing from Melbourne Law School and I'm Director of the Centre for Employment and Labour Relations Law. I'm appearing on behalf of myself and Professor John Howe, who was unable to attend the hearing today.
Oh, wonderful. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Yeah, thank you very much, Chair. I don't intend to provide an opening statement. I just rely on my written submission.
Okay, thank you. If you would like to go first, Senator Payman. We have the call.
Thank you, Chair. Thank you, and good afternoon, Dr. Hardy. Thank you so much for providing the submission. Now, the Fair Work Ombudsman has submitted that, and I quote, "It is not unusual for new penalty regimes to take time to reach the courts, particularly in the criminal context." Now, they cite the example of the serious contraventions which were introduced in 2017 and not brought before the court in 2019. Do you believe this is a fair comparison?
I do. I mean, in the sense that in relation to new provisions, such as the serious contraventions amendments that took place under the Protecting Vulnerable Workers reforms, or more recently, the way in which the serious contraventions provisions been amended under the Closing Loopholes reforms, it's very rare for them to be retrospective in nature. The same is true, of course, of the criminal offence in relation to intentional underpayment. And because they are prospective in nature, it does take some time for there to be a case which is of sufficient seriousness that would justify bringing either litigation with respect to serious contraventions or a prosecution with respect to the criminal offence. It is intended that these are reserved for the most egregious or serious cases, and therefore it does take time for those cases to emerge.
Yep, so it could be years until a criminal wage theft case comes before a court, right?
Yes, I think that's quite possible. Yes, because the relevant offence needs to take place after that provision takes effect, which of course with the criminal wage theft offence was 1 January 2025.
Yeah, no, absolutely. Now, just in the centre's submission, it says it is to be expected that some time must pass following the introduction of the offence before an underpayment occurs, which is of sufficient seriousness and quantum to warrant a criminal investigation and prosecution. Do you believe it is necessary for the Fair Work Ombudsman to employ 16.7 full-time equivalent staff to solely investigate criminal wage theft matters, or would better outcomes be achieved by putting those resources into civil underpayment investigations and only conducting criminal investigations where, as the centre submits, and I quote, denunciation and condemnation is required and where the deterrent effect of a civil penalty would be insufficient?
Yeah, thank you. I mean, it is difficult to answer the question around the number of staff that should be dedicated to a particular jurisdiction. What I would say is that, in effect, what the Fair Work Ombudsman now has responsibility for is a dual-track system that's got the criminal jurisdiction as well as the civil jurisdiction. And the nature of that dual-track system means that there needs to be fairly firm procedural boundaries between the teams that are dedicated to the investigation of criminal matters as opposed to the investigation of civil matters, because any tainting of the investigation that's being undertaken with respect to the criminal offence might compromise the capacity for the prosecuting authorities to initiate the prosecution or to succeed with respect to that prosecution, because the evidentiary requirements with respect to criminal investigations and criminal prosecutions are by their very nature much stricter. There's higher privileges, higher burdens of proof. I'm sure you're familiar with some of those issues. So I think certainly in the inception of a new jurisdiction, I don't think it's unexpected that you would have a dedicated team of 16.7 staff to try and ensure that you've got sufficient expertise on the ground to undertake those investigations with due care and skill.
Yeah, and just quickly on Victoria's wage theft laws, which, you know, criminalise not only wage theft itself, but also the dishonest destruction of failure to keep payment records. Should stronger record-keeping requirements be considered as a way to make the wage theft offence a more effective deterrent?
Yeah, look, it's a really good question because it is, I think, well established now after having, you know, a fairly established regulator in this space for more than 15 years, that records are essential to bringing an investigation and bringing litigation that's seeking to enforce entitlements. My sense is that the presumption that applies where records have not been kept or have not been accurately kept can sometimes be more helpful. So this is the presumption that was introduced under the Protecting Vulnerable Worker reforms. That presumption does not exist with respect to the criminal offence. So yes, you can attach a criminal sanction in relation to intentional destruction of records. That might be something for consideration for those involved in law reform. But at the end of the day, proving a criminal offence of intentional underpayment is going to be more complicated when no records have been kept or there's been intentional destruction of them. So certainly you could attach a separate criminal sanction to that separate offence, and that might lead to sort of a heightened level of deterrence. But as indicated in my submission, I mean, my sense is that criminal sanctions only get you so far when it comes to deterrence, and certainly the research and evidence suggests that there's other ways that are possibly less appealing from a political point of view that actually serve deterrence purposes very well, and that's increasing the perceived risk that you're going to be detected, and if you are detected, you have a perceived risk that a sanction, even a modest sanction such as a fine, a small fine, will be imposed. So the evidence suggests that that is the better way to deliver deterrence. But of course, there's that separate question of deterrence is only one part to promote compliance. So all these things are kind of, I think, important to distinguish between when we're talking about whether or not we're seeking to promote compliance as opposed to enhance deterrence, and what's the best way of achieving both those aims.
Yeah, no, absolutely. And we heard from witnesses just earlier to the committee in sectors like higher education, wage theft doesn't come through a boss taking a bit of money out of a payslip, but through institutional practices like the normalisation of a culture of unpaid labour and forcing workers to go far beyond what is expected of them in order to be eligible for a promotion. Like, do you believe wage theft offence is drafted in a way that effectively encapsulates conduct that constitutes what most people would think of as wage theft?
Yeah, I mean, this comes down to what is the definition of wage theft, because we don't have one in the Fair Work Act. And certainly some of the submissions that I saw from colleagues at the University of Newcastle put forward some really interesting research around the extent to which work is remunerated and paid for. I think the question that I have is the extent to which that work constitutes a breach of the relevant industrial instrument, and so to what extent is there an underpayment that can be the subject of civil enforcement litigation or a criminal offence. So that's sort of the first kind of key question, I think. But assuming that it does constitute a breach of the relevant industrial instrument, then I think in terms of the criminal offence in the Fair Work Act, it's directed at intentional underpayment, but intent is defined very broadly under the criminal code to include a corporate culture. So this is one of, I think, many unresolved issues with respect to the criminal offence that would have to be resolved via decisions about the way in which that corporate culture element will be interpreted and applied in the context of an intentional underpayment. So universities is one example. Of course, there's many others in other sectors of where there might be a corporate culture that has tacitly authorised underpayment.
Yeah, no, absolutely. Che, do I have quite time for one more question?
One very fast one.
Thank you. Just a quick one. So organisations like SDA and NTU have proposed that unions should be allowed to investigate and possibly refer criminal wage theft matters to the police. What are your thoughts on that proposal?
Look, I think going back to what I was saying before in terms of the importance of increasing the risk of the perceived risk of detection is really instrumental to enhancing deterrence. Certainly unions have had a historical role in our system in terms of detection, And I think there is scope for providing them with the capacity to refer. I mean, at the end of the day, it's going to be the prosecuting authority, whether it's Australian Federal Police or the Commonwealth Department of Public Prosecutions, that ultimately decides whether or not a prosecution will be initiated. So a referral is one thing, but they too would have to abide by criminal rules of procedure in order for that brief to be accepted, presumably by the prosecuting authority.
Yeah, thank you so much. Thank you, Chair. Appreciate it.
Thank you. Senator DeLager. Apologies, it's Senator Barbara Pocock.
Thanks, Chair. Thanks so much for your evidence, Dr. Hardy. I just want to follow up on a couple of things. You've sort of given a kind of green light support for unions having the capacity to refer, knowing that the standards and procedures for the AFP would need to be followed and so on. That's what I read from your latest answer there. What's to do that? Unions would need to have, would they not, reinstated their ability to inspect time and work and wages records and have the opportunity to do spot checks. Do you support that reinstatement?
Yes, but within limits.
Mm-hmm.
Yeah, I mean, I think it is important that unions have the capacity to check time and wage records. And I understand that they do have that capacity to some extent already, although obviously that needs to be with notice. And I think that that is part of the challenge. With notice,
it's very constrained in non-union workplaces, though, is it not, where they don't have members?
Precisely. Yeah, it is.
Yeah, which is where we need it.
Yeah, agreed. I mean, to some extent, I think there needs to be a broader conversation about the extent to which unions have the capacity to access payroll software and the records that are kept by third-party providers. So I think there is a really interesting development in the last few years where payroll software providers have really critical data in terms of records relating to employment and pay. My understanding is that unions would not necessarily have the right to inspect that data. And so I think there needs to be, a broader conversation about their rights in relation to what constitutes a spot check. Is it spot check of the employer's records or via the payroll software provider?
So the mechanics of it are an interesting question, but the principle, it's extremely difficult to flush out underpayment if you don't have the capability to have some kind of access to records as a principle.
Yes,
would you
agree
with that?
Agreed, completely. I mean, as I said before, employment records are essential for building a case, but it's quite common for those that are committing the most egregious contraventions in terms of underpayment don't have records. I mean, it might be cash in hand. So in that instance, it's those other rights of entry which are absolutely critical in terms of ability to access workers and ensuring that workers can exercise voice and exercise their ability to access supports, whether it's via unions or other worker representatives or community legal centres, which is essential.
Mm-hmm. So we need the records to be kept. We need to make sure that some transparency in relation to them, and then appropriate penalties and procedures where misdemeanours have occurred.
That's right. And I think my understanding is the presumption has worked to some extent, but there's still scope for also reflecting on whether or not the presumption could be amended with respect to bringing proceedings against employers who haven't kept the records.
Thank you for that. You want to see increase, if I've understood your argument correctly, it's not so much whether there is a big stick of a criminal possible prosecution, successful prosecution. So you think that the disincentive effect of that may not be as great as increased risk of detection with perhaps lesser but significant civil penalties. Have I understood that argument correctly? Is that what you're saying?
I am, yes. So in previous inquiries, I mean, there's been so many over the last 10 years relating to this issue. Certainly in previous submissions, I've put forward recommendations around, for example, compliance notices. So there have been some amendments to the compliance notice regime. I think there's scope for further expansion of the compliance notice regime. So there really hasn't been much discussion around the extent to which inspectors should be authorised to issue a compliance notice which requires rectification of the underpayment or an audit of the workforce to ensure that no underpayments are occurring in relation to other workers beyond those that have complained or been the subject of the initial investigation. But I think there is also scope for thinking about to what extent inspectors should be authorised to issue penalties associated with those compliance notices. So in the same way that there's fixed penalties with respect to record keeping contraventions in relation to infringement notices. So the ATO has capacity to issue notices with fixed penalties attached. And I've questioned previously and I question now the extent to which there's scope for compliance notices to be sort of strengthened in some way. It might be a different name, but I mean, certainly there's been criticism in the past about the fact that compliance notices do no more than require the employer to rectify the underpayment which should have been paid in the first place.
Okay. And are you saying there should be a layered punishment on top of rectification? Yes.
In certain circumstances.
Yeah.
So my understanding is it's not uncommon for employers to not cooperate when a compliance notice is issued or to drag out the investigation or proceedings by not responding. So there might be scope for a penalty to attach where there is no response or there's been late payment. And of course, if the employer has a reasonable excuse in relation to failing to comply with a compliance notice, of course, that would be taken into account and should be. But I think there's also scope for strengthening the hand of inspectors and others that might be authorised to issue compliance notices by attaching a penalty in certain circumstances.
Thank you. A couple of other questions. Well, you mentioned the ATO. We've heard evidence today about the complexity and difficulty, the non-function of having two places, both the ATO and the Fair Work FWO, where breaches have occurred either in relation to super in the case of ATO. And do you see and Fair Work in relation to wages more directly? Do you see an argument, do you agree that there needs to be some simplicity introduced here, and super, which is essentially deferred wages, pursuit of non-payment of super should be pulled into the industrial machinery in a single approach?
Well, certainly I was supportive of the previous inquiry which looked at wage and super theft because I saw them as related in the sense that as soon as you have an underpayment, you've immediately got a superannuation problem in terms of a deficit with respect to remittances. And I've appeared in relation to inquiries looking at superannuation theft. My understanding is the ATO has increased its efforts with respect to investigating and enforcing superannuation entitlements, but I still see the ATO's priorities as different to regulators, which are more concerned with the recovery of employee entitlements. And I see superannuation as an employee entitlement. It's related to paid work, and it does seem that dividing responsibilities for the enforcement of those entitlements as duplicative and inefficient.
And we just see data today, 24 billion in the last few years in super. So we've got a long way to go before we're confident we're actually picking up on super theft.
That's right. I mean, and it affects women most. I mean, there's so many, the way in which superannuation underpayment or failure to remit compounds over time is really disturbing and concerning.
One more very
last question.
Yeah,
last question. You make the point with Professor Howe in your submission, I think, that we have very poor data on the extent of wage theft. Is it time for a more systemic set of data about what's going on in our workplaces more generally? You've obviously given evidence a number of times at inquiries. One of the reasons I think as a refugee from the academic sector is that we spin our wheels in this space a lot because we don't have good data that we can all agree on to guide policy making and legislative change. What's your perspective on that?
Yeah, look, I mean, it's always a question of obtaining the relevant data in order to guide decision making around policy or implementation. And certainly we've tried over many years to try and better understand the way in which enforcement, whether it's changes in the law or changes in the way in which the Fair Work Ombudsman's undertaking certain activities or unions are undertaking certain activities, to what extent we can see whether or not it's made any difference to business behaviour. Because at the end of the day, that's sort of the kind of the aim of the enforcement framework. It's difficult. There's no baseline data, and it's very, very hard to obtain economy-wide data on rates of compliance or rates of non-compliance for lots of different reasons. But more challenging is actually then trying to isolate the effect of criminal wage theft offence or serious contraventions. It is very difficult to say that a certain case has changed behaviour across the board. Often it's confined to sectorial effects or regional effects. But certainly our research has also shown that it's the extent to which the media coverage has amplified the deterrence effects or kind of increased knowledge and awareness of a particular case or a particular matter, which has generally had the most impact on business awareness. And of course, that's the first step in the business has to be aware before it can be deterred from non-compliance, and that's the kind of grand challenge, I think, when it comes to promoting compliance more generally.
And isn't not also...
We really need to move on, Senator Pocock.
I'm just asking whether you agree with this. It's also important to have information, for example, about the level of precarity in a workplace or an industry to contextualise whether certain remediation or legislative outcomes have an effect. But we need a fulsome picture of what's going on in workplaces.
Yeah, and I would also suggest that it's the way in which businesses are structured, which is also important. We know that certain business networks and business structures can lead to greater levels of non-compliance because of the way in which lead firms can influence sort of incentives to pay profit margins, etc.
Thank you. Thanks for your indulgence, Chair.
Thank you. Senator De Jager.
Thanks very much, and thanks for joining us, Professor. I just wanted to ask you about the Centre's report titled Underpaid and Overlooked, the Wage Crisis Facing Young Workers in Australia, published last year in July. The research examined the extent to which young workers are highly vulnerable to incidents of wage theft. For the committee's records, could you please provide an overview of your findings regarding the prevalence of underpayment for young workers?
Well, thank you for your question. I might take that one on notice because it was my colleague John Howe who was the lead author on that study, and I would hate to misrepresent the key findings. And certainly the report itself, I think, provides an excellent summary of the key findings. But you're quite right. I mean, in terms of the report, it certainly confirms some of the earlier research which suggests that younger workers are very vulnerable to being underpaid, but also find it difficult then to access the support and resources in order to seek redress or seek to have that underpayment rectified. But if you don't mind, I might take that question on notice and allow John to provide that summary for you.
Very, very happy for that. And I just wanted to ask, also if you need to take it on notice, that's fine as well. About the report, and you made several recommendations to address the issue. And obviously, the government has introduced the criminal offences for wage theft and intentional underpayments, and increased the civil penalties. Do you support the new laws to criminalise and to increase those penalties?
Certainly. I mean, I think that it is an important part of the regulatory mix. I think, again, there's more that could be done when we look at kind of optimal regulatory enforcement. The ability to incapacitate particularly repeat offenders is really important. So labour hire licensing is a really critical way in which you can amplify those effects by revoking a licence where you've got a business who has committed an egregious offence or repeatedly done the wrong thing. And I do think that there is more that can be done in relation to disqualification of directors, whether it's where they have been found to have committed a criminal offence or where they have been found to be liable for a serious contravention. I think a conversation needs to be had around whether those directors should be permitted to continue to open up new businesses and employ people, or whether they should be disqualified, and who can seek those disqualification orders. At the moment, it's reserved to ASIC. I do wonder whether or not there's scope for the Fair Work Ombudsman to be empowered to seek those types of orders.
Trade unions perhaps as well?
I mean, to the extent that ultimately it's within the court's discretion to grant those orders. So, to the extent that unions have standing to enforce civil remedy provisions under the Fair Work Act, ordinarily they can seek the orders that are available under the remedial provisions of the Fair Work Act. So I would suggest that they should be authorised also to seek those types of orders, because ultimately it will be a decision for the court as to whether or not those orders are appropriate in the circumstances of the case. But agreed. I mean, I think it's important that unions also have the capacity to bring enforcement proceedings and access remedies that would support compliance and ensure that repeat offenders are removed from the market, because it's not good for employees, but it's not good for complying businesses either, that they're being undercut.
Absolutely, and we heard that earlier, evidence in the security industry as well. So thank you very much. I'll hand back to the chair.
Thank you. Just a few questions from me. Paragraph 4 of your submission talks about wage theft not being defined in the Act and lacking a settled meaning. In your view, is it accurate and perhaps fair to call an inadvertent underpayment theft, because we're sort of seeing that narrative building as well?
Yeah, look, I think I try to avoid using the term wage theft, but I also accept that most people post 7/11 adopt that term to refer to all different types of underpayment, whether it's deliberate or unintentional. I understand the concerns associated with labelling all forms of underpayment wage theft, and I generally try to avoid using it, but also accept that that it is a term that's commonly used.
The Section 327A captures primarily the intentional conduct. The explanatory memorandum is explicit that accidental, inadvertent, or a genuine mistake underpayment should not be caught up. So when unions and other groups focus on the wage theft element to describe any underpayment, do you think that impacts the ability to actually properly target actual wage theft, because it captures everything? And are we sort of I guess, creating some more barriers for ourselves by trying to be broader than what Parliament actually criminalised?
Well, I can't speak for the way in which unions advocate for their members.
No, I meant the narrative, the discussion of it all being that way. So if we're talking about it all being theft, which is where sort of a lot of the discussion from the union movement is, does that sort of hamper our ability to target real theft if we're calling it all theft?
And when you say real theft, are you talking about intentional underpayment
intentional
as
and deliberate
criminal offence, as opposed to? I mean, the reason I ask you that as chair is because there's certainly research which suggests, and this is part of the reason why it becomes complicated very quickly, is that there's certainly research which suggests that sometimes intentional, deliberate, egregious underpayment is still seen as a white-collar issue, a corporate crime issue, which is less serious or more trivial than real theft in terms of a burglary. Certainly, and I don't know whether it's confined to unions, to be quite honest. I feel like the media has also adopted this term.
You're probably right there, I would say, yes. Some elements.
And at the end of the day, I don't think it necessarily hampers the capacity of the regulator to initiate investigations or prosecutions, because they do so with, I think, a keen eye on satisfying the elements of the offence as opposed to what terms being used. I guess the extent to which employers who want to do the right thing feel maligned because this term has been used in the media or by unions. Certainly, there is evidence that suggests that, you want to encourage employers who seek to do the right thing to continue doing the right thing and not.
It was also around that awareness piece that you were speaking about. So if you're actually talking about people that do the wrong thing and plan ways to effectively underpay their workers, as opposed to people that make genuine errors. And we've seen errors recently from the Department of Education and Workplace Relations, from the Commonwealth Bank, from the National Australia Bank, who I would assume are all organisations that had no intention of stealing from their employees but made errors. Does it sort of make that public conversation harder if they're bundled together, I guess is where I was coming from.
I'm not sure that, those employers are pretty sophisticated, to be quite honest, and they have access to good advice. So I'm not sure that they're necessarily worried about that. Certainly, the research suggests that where employers are seeing businesses that are particularly businesses that they see as deserving of criminal sanctions or hefty penalties, where they see those litigations taking place, it can have a reminder and reassurance function. So the employers who are doing the right thing or investing resources in compliance can feel like that investment is not wasted, that investment is justified in order to ensure that they continue to do the right thing by their employees and their shareholders.
Paragraph 11 of your submission lists lack of awareness of the relevant laws and an absence of necessary resources to support accurate compliance as one of the drivers of non-compliance. And that sounds like businesses, to me, particularly struggling with red tape complexity. And we spoke about those couple of examples who are, quite sophisticated. So for me, it seems like complexity, not theft, where it's inadvertent. Would that be a fair assessment?
That complexity is one reason why employers do not comply?
Correct. So complexity is part of the problem, and it's not around. If it were simpler, more businesses would comply because they would know how to comply. So the complexity of the system in itself creates part of this problem.
Yeah, possibly. Certainly our system is not the most simple system that I've come across, and when I've looked at different workplace relations systems across other countries, but the complexity is also part of it's an important feature of our system in terms of the way in which it ensures protection, particularly for vulnerable workers who are in non-union workplaces and aren't in a position to negotiate enterprise agreements. So certainly one way in order to minimise or avoid some of the complexity associated with the modern award system, for example, would be to negotiate an enterprise agreement. But I appreciate that not all businesses or not all employees are in a position to do that.
Yeah, and I guess this is sort of, my mind is sort of going, well, if knowledge, awareness, capacity are main drivers, and we have sophisticated organisations making mistakes, including the Department of Employment and Workplace Relations themselves, isn't the highest leverage intervention making the rules simpler? Not adding criminal sanctions. So how do we make it simple so employers get it right so that every employee gets paid what they're entitled to? That's sort of where my mind is going. Am I missing a key step there?
Yeah, look, I think it is important to understand that certainly certainty of regulation and clarity of rules is important in terms of promoting compliance. But that has to be weighed up against ensuring that in seeking to clarify or in seeking to simplify the rules, you are not lowering the standards. So the example that springs to mind is the High Court decision in personnel contracting, which on one level you would say is a simpler way of characterising employees because it was largely determined by the express terms of the employment contract. And the multifactorial assessment that was established by Hollis and Verboo and kind of reinstated in sense by the closing loopholes reform is a more complicated assessment in that it's more contextual and it's factual, it's reality tested against what's actually occurring in practice. But that there is, I think, very good arguments to suggest that the more complex system is the fairer one in ensuring that workers are not sort of written out of the law by virtue of employment contracts, standard form employment contracts drafted primarily in the interests of the employer.
Yeah, and I guess my thought then is, are we then accepting that, playing devil's advocate, that one of the unintended consequences of complexity is that sometimes, for all their best efforts, organisations, large or small, sometimes get it wrong?
Yeah, I mean, I think that I accept, and certainly our submission indicated that compliance is driven by a range of factors, and a lack of awareness or capacity is one of those factors. But it's certainly not the sole factor, and it's not an exclusive factor. And I do think that there is still scope for ensuring that the range of compliance motivations are addressed, not just simply assuming that it's only complexity that's driving non-compliance, because I think you see in many industries and many businesses are able to comply with other complex laws, whether it's tax laws or corporate laws, because I think they recognise the significance of non-compliance with those laws. So that suggests that there is at least some capacity to comply with workplace laws.
Thank you so much, and thank you for your evidence today. If you've taken any questions on notice, if you could please return the answers to the Secretariat by Monday, 18 May 2026. Thank you.
Thank you very much for your time. Thank you.
I now welcome representatives from the Department of Employment and Workplace Relations and the Fair Work Ombudsman, both in person and via teleconference. I'll just wait for those representatives to come to the table. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked to the officer, to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. For the Hansard record, if you could each please state your full names and the capacity in which you appear today.
Thanks, Chair. Elizabeth Brayshaw, First Assistant Secretary, Entitlement Safeguards Division.
Lavinia Gracia-Kanchevska, Assistant Secretary of Workplace Exploitation Branch.
Emma Hallis, Assistant Secretary and Senior Executive Lawyer of Employment Standards and Institutions Branch, Workplace Relations.
Thank you. And online?
Rachel Volsky, Acting Fair Work Ombudsman.
Thank you.
Michelle Carey, Group Manager, Regulatory Transformation, Fair Work Ombudsman.
Thank you. I'll now invite you to make a short opening statement. At the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thanks, Chair. The department doesn't have an opening statement. We're ready to answer questions.
As are we, Senator, from the Fair Work Ombudsman. And even though they weren't introduced, I understand there are a number of other Fair Work officers online as witnesses as well.
If they will be answering questions, they will need to introduce themselves now, if that's okay, please.
Anthony Fogarty, Executive Director of Policy at the Fair Work Ombudsman.
Megan Cooper, Executive Director of Criminal Investigations.
And Phoebe Nicholas, Executive Director, Legal Compliance and Enforcement.
Thank you. Senator Payman, you have the call.
Thank you, Chair. Good afternoon, all. Thank you for taking part and appearing before the committee. My question is to the Fair Work Ombudsman. Is there any evidence you can provide the committee with, that demonstrates a statistically significant decline in wage theft in Australia since the criminalisation of wage theft?
Senator, thank you for the question. I think consistent with some of the evidence that's already been given today, it's probably too soon to make a objective assessment as to whether or not the introduction of the offence itself has led to a decrease in the incidence of wage theft. Certainly, and I think as we foreshadowed in our submission, early indications anecdotally suggest to us that employers are really investing in trying to make sure that they are getting payments to their employees right. We've had some increases in self-reporting data, and if they continue on existing trends, will likely be about double of the self-reporting data numbers that we received in the early 2020s.
So essentially the answer is no. The Victorian Trades Hall Council and the Young Workers Centre have submitted that when the Fair Work Ombudsman calculates underpayments, it often looks at only part of the employment period or not all of the entitlements owed, which leaves workers still out of pocket after the matter is resolved. Now, does the Fair Work Ombudsman accept that this happens? And if so, what's being done to ensure workers receive full restitution?
So, Senator, just to clarify the answer for the last question, I said it was too early, not that it was no. So if I could just make sure that the record reflects that. As to that question, I'll hand over to Megan Cooper and also Phoebe Nicholas, who are responsible for our compliance and enforcement activities, to explain the reasons why we might, choose a particular time period in relation to any particular proceedings that we might bring. Noting, of course, that we've also got other enforcement tools available to us, enforceable undertakings, for example, can remediate for periods outside of the statutory time limit as well. So there's I guess a number of factors that go into, those deliberations, but I'll hand over to my two colleagues to provide some more information.
I think people are on mute, maybe.
I'm perhaps happy to address that first, Senator. In relation to matters where the Ombudsman pursues enforcement tools, so we would capture within that litigation, enforceable undertakings and compliance notices, infringement notices and so forth, the FO does in some instances make decisions about what aspects of an employee or a cohort of employees' entitlements might be included within that activity. And that would be informed by a range of factors that will be very much on a case-by-case basis. But a couple of quite relevant considerations would be the availability of relevant and, where applicable, for instance, if we were looking at a litigation outcome, admissible evidence to establish those allegations. That is, the FO might decide not to press all allegations that an employee brings forward if we don't consider that there would be adequate evidential or legal basis. And, for instance, in respect of a compliance notice, that might be the reasonable belief level. For a civil litigation, that might be to the balance of probabilities. We may, however, take other parts of that person's claim forward where we think that the evidence is adequate for the exercise of the tool that we consider is appropriate. The other component I would say is we in our public-facing compliance and enforcement policy outline our strategic enforcement model, and particular aspects of conduct which the FO might consider appropriate for enforcement would be considered in accordance with that strategic enforcement model and the public interest arising in that particular matter. And that might mean, for instance, that if the FO is selecting a particular type of conduct to seek deterrence in respect of litigation, that our litigation has a particular focus on certain types of contravening conduct.
Now, just on reducing the high level of proof required to secure a criminal wage theft conviction, which would obviously make it easier to prosecute wage theft and, as a result, make the offence a more effective deterrent. Does the Fair Work Ombudsman believe any of the fault elements of the offence should be lowered? And if this were to happen, would a more visibly effective wage theft offence better justify the government's investment in Criminal Wage Theft Office?
Senator, I might just start on with that, but then hand over to Ms Cooper to address that. Again, I'd say it's probably a little bit too early to make any sort of assessment around that. And obviously, as the regulator, we'll apply the law as it stands. But I'll hand over to Ms Cooper for any other specific observations that she'd like to make.
Thank you, Senator. As Ms Volsky has said, it is not for us as the regulator to determine whether or not the offence provision is sufficient. It is our job to investigate and enforce it. What I can say is that is what we are doing. We have active investigations into alleged underpayments, contrary to Section 327(a) of the Fair Work Act, and we will continue to investigate matters with a view to referring them to the Commonwealth Director of Public Prosecutions in accordance with our compliance and enforcement policy.
I understand your job is there to investigate. Now, $49.5 million was allocated over 4 years to the FO to investigate allegations of criminal wage theft. Can you please advise the committee how much of this has been spent for this purpose to date?
Senator, I might take that question at first instance, and then Ms Carey can provide some further information. It may well be for this financial year that we will provide whatever additional information that we can on notice. But earlier today, I think there's been mentioned by previous witnesses that in establishing this jurisdiction, we're now a dual-track regulator. So obviously just before we were exclusively a civil regulator, and now we are both a civil and a criminal regulator. So really, some of that funding, particularly front-ending in, still relatively recent introduction of the offence. It's about, standing up the function as well as all of the, enabling operations that happen around that. And then certainly as we move forward, it would be my expectation that it will move, to a state where it's more investment in those operational activities. But if Ms. Carey is available, it would be great, Ms. Carey, if you could set out some of that detail around those, standing up capabilities.
Thank you. Thanks, Senator. So we've outlined some of this in our submission, Senator, but in the shift, the uplift for this agency in moving to a dual track regulator involved a significant amount of investment in terms of implementing systems, processes and infrastructure to support investigating criminal offences. So we sort of had the implementation phase, and so that involved quite a significant investment in technology platforms. So technology platforms that are capable of supporting, storing evidence and chain of custody requirements to a criminal standard that would support the referral of matters to the CDPP and meet admissibility requirements for a successful criminal prosecution. One of the challenges that we encountered in moving to a dual track regulator is that our existing civil investigation infrastructure isn't satisfactory and doesn't meet those appropriate standards. So there's been quite a significant, technology investment for us in terms of platforms and case management systems. We also had to invest in physical infrastructure, so that's to manage evidence to a criminal standard. So that includes things like, secure evidence rooms and storage facilities, specialist IT devices. We've also established interagency arrangements where it's most efficient to do so in terms of expenditure, and that includes arrangements with the AFP to support the Fair Work Ombudsman in relation to execution of search warrants, and Engaging Services Australia to support criminal investigations in relation to expert forensic support. In addition to that, we obviously had to develop a range of internal policies and training and standard operating procedures to support the segregation and ensure that the way in which our criminal investigation stream interacts with our civil investigation stream, that is also led to training across the agency for all of our inspectors. And at that front end, we also invested quite significantly in our guidance material, our website material, our education activities and our communication activities. And we also engaged with our tripartite stakeholders in relation to the development of a range of resources, including the voluntary, in relation to the code, and also cooperation agreements, which I know were discussed earlier today. As we've moved into the operating phase of the offence since the 1st of January, we've obviously, and again, this is in our submission, we've got ongoing labour costs that support a specialist criminal investigation team, but that's not the sole investment of that money. There are a range of existing staff across the Fair Work Ombudsman that support the criminal investigation functions, and that includes staff that assist with the identification and assessment of potential matters for criminal investigation. So as you can imagine, as matters come through for referral, they're assessed at different stages of our multiple channels. We have teams across the agency where we've augmented existing teams, but they also provide support to the function. So that would include our legal advice team, our intelligence team, the teams that undertake calculations to quantify underpayments that would support a referral for a criminal prosecution. We've got staff that are specialised in handling the evidence to the criminal standard. And then we've got corporate enabling services, so those on costs that are associated obviously with property and people. So we also have ongoing operating costs in relation to those technology investments that I mentioned. So needing to fund the protected environment.
I'm mindful of the time, Ms. Carey. Thank you for that breakdown and talking about the phases, but I still haven't got a figure of how much of the $49.5 million has been spent for this purpose to date. If you need to take that on notice to actually bring back, some numbers to the committee, because it's good to go through all the details. Because my next question is, how many referrals of criminal wage theft matters to the AFP and CDPP have occurred to date?
Senator Payman, this will need to be the last question. We're over the allotted time. Thank you.
So we can take the question of the numbers, Senator, on notice. So to date, no referrals have been made. As set out in our submission, since the commencement of the offence, we've assessed 39 matters. 4 of those have progressed to what we would call full operations, and 3 of those remain ongoing. We have a further 7 matters on top of that that are currently in the assessment phase, and the assessment phase involves preliminary investigative steps. So that does involve speaking with witnesses, issuing notices to produce, and obtaining
just
evidence.
as I'm time poor, just so I'm clear, in 488 days since the offence commenced, and we've highlighted, I'm not sure exactly how much of the $49.5 million have been spent, but millions of dollars have been spent and not a single matter has been referred to the authorities as yet.
That's right, Senator, but I would say that as evidence has been given earlier today by multiple witnesses, we would say that that is not unusual where there is the commencement of a new provision, and that in the context of both the Fair Work Act and other legislative schemes, it's not unusual for there to be a period of time before a matter progresses to a referral.
I understand, but it's been like more than 15 months, and I think, you know, this piece of legislation isn't doing what it's set out to do, and this is taxpayer dollars that have been spent and not really giving us an outcome that we were hoping for. But thank you, Chair. I will put the rest of my questions on notice.
Thank you. Senator Delaga, you have the call.
Thanks, Chair. Thanks for coming along today. First question for the Fair Work Ombudsman, if I may. What type of industries are we seeing where wage theft is most commonly active in, and what kind of workers are disproportionately being affected by wage theft?
Senator, I might call on Mr Fogarty to talk more broadly about that, but I think that, you know, sort of the premise of the question goes to that, you know, what do we understand to mean wage theft, and that covers a whole gamut of conduct, obviously, from the intentional to that is, you know, honest mistakes. We obviously have enduring priorities for vulnerable workers, which include, you know, people who are young, those from culturally diverse backgrounds, etc., as well. So if I could call on Mr Fogarty to provide detail around stats, please.
Yes, thanks, Ms Volsky, and thanks, Senator. I might break that up just in 2 ways for you, Senator. So the first is, if I look at the top 3 industries where we receive inquiries, so people coming to us making inquiries, and that can be either employers or employees. The top 3 industries where we're receiving inquiries for the current financial year. So the top is healthcare and social assistance is number 1. The second is construction, and the third is accommodation and food services. If I then look at the top 3 industries for what we call requests for assistance. So, Senator, if you think about it, when we're looking at inquiries, we receive around 300,000 inquiries per year, and then we filter those down to those people workers that might request assistance, saying that they might have been underpaid or they don't think they've received all of their entitlements, and then we will look into that matter for them. So the top 3 industries related to requests for assistance, the top one was accommodation and food services, the second one was construction, and the third was healthcare and social assistance. So the same industries, just in a slightly different order, Senator.
Thank you. And the type of workers in specifically, are these insecurely employed workers, or do you have any information about that? Or
I don't think I have anything really about status of employment in front of me, Senator.
Okay, no worries. I might just on the theme of the reports. unions have reported that prior to the introduction of the wage theft provision, businesses that deliberately stole from their workers factored in the penalties as just the cost of doing business. Now, do you have evidence of businesses coming forward to self-report underpayments since the introduction of these provisions?
Senator, as I mentioned in my earlier evidence, we have seen an uptick in businesses reporting, and we see that as a positive development that employers are investing to make sure that they are, doing the right thing and paying their employees correctly.
And do you have any information about how much that increase has been by?
As in the number of people who have self-reported. Yes, Senator, it's in our submission, but also I think I might just be able to, let me just have a look. Yeah, so in 2025, we received 162 self-reports, which is an average of 3.1 per week. But in the first half of this financial year, so 2025-26, that's increased to 91 or 3.5 a week, which, as I previously noted, was tracking towards almost double the number of self-reports we received in 2021, where we had 92 businesses come forward, which was about an average of 1.8 a week.
And as part of that self-reporting process, do you then provide support to those businesses on how they rectify the case?
We absolutely do, Senator. So that's part of our triaging process, really, and making sure that we, are ensuring the integrity of the remediation program. Obviously there's no particular sized employer that can, decide to self-report to us, but we've got information set out in our publicly available compliance and enforcement, policy around that. But certainly that is our objective, to ensure that there's an integrity around the remediation, and ultimately also that, so that occurs at the employer's expense. We also, in the middle of last year, I think it was around August, we also released a remediation guide as well to assist employers through that process.
And when it comes to the voluntary small business compliance code, how does that code support businesses to come forward and self-report, and in the safeguards that it provides that offer to small businesses? Because obviously we know that there's a clear difference from people who deliberately want to do the wrong thing, who steal from workers, and the businesses that need genuine assistance to do the right thing. Can you talk me through that?
I can, Senator. So as part of the implementation of the new criminal offence, we were tasked in the legislation to develop that code, and we did so in consultation, obviously, with our colleagues at the department, but also through a tripartite process with employer and union stakeholders. So that was done over a series of months, and the code itself is an instrument that is declared by the responsible minister. But the other piece of education that supplemented that as well, and certainly came out of the tripartite process, was the importance in developing something really, I guess, akin to a checklist or guide to assist employers, to how they can ensure that they pay their employees correctly. That is available on our website. Again, that was developed in tandem with the code, and it's something, certainly as its primary audience is geared towards small business employers, but we're also keen to make sure, in combination, I guess, with that remediation guide that I mentioned just before as well, that there was clear information and advice available to all employers on our website that could walk them through the process of trying to undertake the checks and balances that they need to ensure that their employees are paid correctly.
And does the Fair Work Ombudsman believe that the criminal offence provision is effective in encouraging employers to comply with their obligations to pay workers what they are owed?
So, Senator, as I previously noted, it's probably too early to tell. I'd also say, and I think consistent with some of the evidence that's been given earlier today, that there were a suite of changes that were brought in. You know, the increase in penalties for serious contraventions. Obviously, I think the figure is about $4.5 million. So I would say a suite of those together work. It's not just necessarily, you know, one measure. We're still yet to, you know, make use of those increased penalties more broadly that came in via closing loopholes, although we do have a couple of compliance notice matters where we have those matters on foot at the moment where we are looking to make use of those increased in penalties. But that's, you know, reflective that the compliance notice, I guess, is at the lower end of our enforcement tools. It's, you know, generally considered to be non-punitive, so it would make sense that through the pipeline, you know, it would be a quicker amount of time that we can start to make use of those increase in penalties.
Thank you very much, and I wish the Ombudsman well in your future endeavours to tackle this serious matter. If I may just ask a quick question to the department. In the former Minister for Education and Employment and Workplace Relations second reading speech on the closing loopholes legislation, the Minister said, in relation to wage theft, it is already a crime for a worker to steal from an employer, as it should be, but it's not a crime for an employer to steal from a worker. We will close this loophole. Can the department inform the committee of what measures we're including with the legislation to close the loophole and address wage theft?
Thanks, Senator. In relation to the closing loopholes reforms, that's right. In addition to the criminal wage theft offence, which was introduced very much to tackle intentional wage underpayments and to help promote a more robust compliance culture, the legislation also introduced several amendments to strengthen the Fair Work's civil remedy provisions to address underpayments by setting maximum penalties, and there are a couple of other measures which I might get my colleague to talk through. These measures were very much informed by the work of not only Senate inquiries but the Migrant Workers Task Force report that looked at the fact that there is a range of underpayment conduct happening in the system, and that there was a need to look at improving and strengthening both the civil remedy provisions but also the criminal penalties. But I might hand over to my colleague.
Thank you, Senator. As Ms Brayshaw mentioned, the wage theft offence sits alongside the broader compliance and enforcement framework under the Fair Work Act, and that includes the civil penalty regime. So the closing loophole number 2 amendments implemented a number of changes to this framework, and specifically that increased the maximum civil penalties for standard civil breaches and serious contraventions of certain civil remedy provisions for bodies corporate that are not small business employers. And as Ms Brayshaw flagged, this is in line with the government's commitment to implement recommendations of the Migrant Worker Task Force report. The amendments changed the threshold also for what constitutes a serious contravention from one that is done knowingly and systematically to one that is done either knowingly or recklessly. And this includes those serious civil contraventions work alongside the wage theft offence, which was introduced and commenced on the 1st of January 2025. For individuals and small business employers, the maximum penalties for most provisions did not change from what was previously in the Fair Work Act, including for serious contraventions. The penalty for non-compliance with a Fair Work Ombudsman compliance notice was brought into line with other underpayment-related penalties. So that shifted from 30 penalty units, which is around $9,390 for an individual, to 60 penalty units, which is around $18,780. I might pause there and just see if you had any specific questions about.
I think I've exceeded my time, so I'll pass back to the chair. Thank you for your evidence.
Thank you so much. Senator Barbara Pocock, you have the call.
Thank you, Chair, and thank you all for being here. A few questions. I just wondered, given that you think it's the general feeling is from some of you that it's too early to evaluate the changes to the regulatory framework. Two questions. One is when you think it would be appropriate, and secondly, how do you plan to evaluate?
So, Senator, I might take the first part of that question and then perhaps turn to Ms Carey and Ms Cooper for the second part. But I think the reason why I'd say it's probably too early, even by civil standards, I don't think enough time has elapsed since the commencement of that provision and offence to be able to, meaningfully be able to make a referral. I think there was some previous evidence earlier that even in the civil context, it can take anywhere between 18 and 24 months to get a matter into court, and albeit a shorter time in the small claims jurisdiction. But when I try and look at, what is the most comparable, regulators in this space, we know that in Victoria, prior to the introduction of a national wage theft offence, there was an offence of wage theft in Victoria, and even that offence, it was some 17 months before those proceedings were commenced. But importantly as well, there wasn't the interposing of a referral to the CDPP or the AFP to actually commence those proceedings. Instead, the wage inspector at Victoria was able to bring those proceedings in their own names. And obviously the matters that they've commenced since that time have been focused on those areas that are within constitutional power. So long service leave, which was also,
If I can just call, I'm asking you to briefly tell me when and how. Please be brief.
Yes, and we are working as quickly as possible, Senator, on referrals. As Ms Carey's mentioned, there are active investigations underway, and I'm confident when we've done the work that we need to as a regulator that's bound by Commonwealth model litigant obligations, that we will make that referral. Ms Carey,
you haven't answered my question in any way. I'm sorry. When do you think is an appropriate time for a parliament to make an evaluation of these changes, and how will you would you make such an evaluation? If you could be brief and answer my question.
Yeah, sorry, Senator. So obviously the closing loopholes review is underway at the moment as well, so they may have some additional observations. I think probably as the regulator, it's difficult for me to make an assessment about what the appropriate time might be from a policy perspective. Okay, thank you. I want to go to your budget. I'm not. Could you tell me, of the 49.5 million allocated over 4 years, is that fairly even spaced year by year? Ms Carey, are you able to?
Yes, Senator. It's approximately $11 million departmental appropriation per year ongoing.
Thank you. How does that compare to the total budget of the Fair Work Ombudsman? Ballpark, if you could give me ballpark.
I think it's around 180 million, Senator, but don't hold me to that exact figure.
Thank you. Is any part of that budget being used in the current year for external agents or consultants?
It's the only external expenditure in relation to that funding, Senator, relates to our engagement of Services Australia, who provides us with expert forensic support and potentially payments in relation to warrant execution associated with the AFP.
But no other external spending?
No.
Thank you. I wanted to go back to the numbers that we had on outcomes to date. You had three investigations that were ongoing and another group in an assessment phase, and 4, I didn't quite catch the language you used in relation to the 4 investigations. Can you just revisit those numbers and explain more clearly what they are?
Thanks, Senator. Probably the best way to frame it is obviously numbers move around, so there are ons and offs as time passes. So since the offence commenced, we've assessed 39 matters for criminal investigation. 4 of those have proceeded to full investigations of potential criminal offending, and 3 of those remain ongoing. So 35 of that 39 did not progress to criminal investigation. There's then a further current 7 matters that are in the assessment phase as to whether or not they will progress to that more fulsome, resource-intensive criminal investigation.
Thank you. We've heard quite a bit of evidence today about how the bar is high in relation to establishing intention. Is that true? Can you comment on that in general terms in relation to the investigations you have afoot?
Might pass that to Ms Cooper, who heads up our criminal investigations team, just to discuss the standard.
Thank you, Senator. In relation to your question, how I would answer that is that the offence provision provides that intention must be established, and that is beyond reasonable doubt, which is the criminal threshold, and that is what we must do. In terms of whether it is too high or not, it is not really for me to comment on that because that is what Parliament has enacted. And what I would say is it is a significant, it is a serious offence. It attracts significant penalties and investigations of this nature, unsurprisingly, take time. They're complex and they take time. To prove intent, it is a high bar, Senator. There's no doubt about that. But my understanding is that that is intentionally so because the offence does not capture inadvertent or mistakes, inadvertent conduct, mistakes, accidents. It relates to where an employer has engaged in conduct to intentionally underpay their workers. That is the space within which we are investigating offending. That is what our 3 ongoing investigations are considering, and that is what we are working towards building a brief of evidence to refer to the CDPP.
Can you comment on the question of a culture in an organisation that creates the effect of intention? We heard some evidence on this earlier from Dr. Hardy, I think it was, that culture can be influential. It's not that there is an email saying, please cheat this worker. It is that there are practices in a workplace that result in and would be expected to have that result. They're intended to have that result. Can you comment on that? And also, could you comment on bigger and smaller or more complex organisations and more smaller, more simple organisations? Is there a difference in the way your investigations unfold in those different kinds of structures?
Yes, Senator, in relation to your first question, which is about, I think, how we attribute the fault elements where we have non-natural persons who have committed this offence. So where we've got companies who are engaging in conduct, how do we prove that they have done that intentionally? And what I would say is that the Fair Work Act picks up Part 2.5 of the Commonwealth Criminal Code, and that provides attribution mechanisms whereby we must prove that beyond reasonable doubt in order to establish that that company has committed the intentional underpayment offence. Now, one of the ways, and 12.3 sets out the ways in which we can do that. One of the ways that has been provided by the legislation is through corporate culture provisions. So what we could do is consider that, but obviously, Senator, it's very difficult to consider these matters in the abstract and to provide any sort of considered view because what it will depend upon are the particular facts of that matter applied against the legislative context. So that is something that I would say is not beyond the pale because the legislature has obviously provided a mechanism by which corporate culture can be relied upon to prove intention. And perhaps I'll turn to your second question, Senator, now, which is in relation to, if I've correctly understood it, is in relation to how, Senator, I might get you to ask that question.
Yeah. I'll just use the example of universities. There are many decision makers through many layers of a complex organisation that have resulted in significant wage theft. That's a very different circumstance to, a much smaller organisation where there are one or two key decision makers. Have you found that there are very big differences between complex and more simple organisations? Is there any comment you can make about where we're most likely to see investigations that are fruitful?
Senator, what I would say is I can't comment on what we have found specifically in relation to our investigations, because to do so would risk prejudicing those investigations which are on foot. But what I can do is make a general observation, which is that the more complex the business structure is, then obviously that would be expected to increase the complexity of the investigation. So where you have a smaller business structure, where individuals are not so distanced from the conduct that might have been engaged in, you would expect that may be an easier offence to prove, but that doesn't mean that where you've got big or small or medium that you can't prove the offence. It just means that the investigation may be more complex.
Last question, Chair, may I ask?
Very quickly, go for it.
Yeah, thank you. I wonder whether the Fair Work Ombudsman has any comment to make on evidence we've heard about the dual track of pursuit of wage theft versus super theft, and the fact that there are those two tracks, ATO and Fair Work Ombudsman, and whether there would be an argument for more simplicity. I know potentially it's a reflection on policy, but I wonder if your experience would lead you to make a comment on that.
Senator, I would echo what's been said previously, that certainly the tax legislation can be complex, but we are very keen. I think one of the issues that would make a difference for us at the moment, we don't have access to single touch payroll. That gives us real-time ability to see how employees are being paid. So I think there's a number of things that could happen in this space. It's a complicated question, particularly because super is different to other employee entitlements in the way that it's employers making a contribution to avoid the charge, so it operates in a slightly different way. But I think there's certainly improvements that could be made.
Thanks so much for all of your answers and your work. Thanks, Jen.
Thank you. I'll try and be very brief so you can all get back to doing what you were doing before you joined us today, and we thank you for your time. Ms. Wolski, page 2 of your submission talks about wage theft being not a defined concept in the Fair Work Act and doesn't have a single settled meaning across the community, which we've heard from others today as well. And you also cite Associate Professor Hardy's article in support of that point. As the regulator responsible for enforcing the Act, do you accept that the term used in public debate is now routinely capturing conduct that falls well outside of what Section 327A actually criminalises, and does that create any additional problems for you?
So, as the regulator, the first thing that we do with conduct when it comes through the door is test it against the Fair Work Act provisions, and it is why we do try to avoid that term wage theft, because of that public discourse around it, and that's played out today, obviously, as well. Look, what we've really focused on is a really significant education and communication campaign to make sure that employers, both large and small, can feel well supported in making sure that they're doing the best that they can to pay their employees correctly. I think also, and again, it's something that we try to publicise both, through our tripartite processes, our advisory group, but also more broadly, that we do take that graduated approach, and really what we want to do first and foremost is support as many workplace participants to meet and comply with all of their obligations across the board.
Thank you. And just my last one quickly. Of the $2.6 billion the Fair Work Ombudsman has recovered for workers since 2009, your submission discloses that approximately $1.9 billion of that has come from underpayments that businesses have voluntarily self-reported. Is that consistent with a picture of that widespread wage theft, or is it more consistent with that education piece that you speak of actually working and employers identifying historical errors and coming forward in good faith to fix them?
Look, I think it's a combination of both. We only started recording those statistics, I think, at the beginning of 2020. But I think also, some of our larger litigations are also demonstrating that there are, significant historical issues that are working their way, still through the courts at the moment. The Coles and Woolies litigation that's ongoing at the moment is obviously, an example of that, which is really about, trying to get, clarity, taking into account, I guess, what has been said in earlier submissions around, sort of the legitimate use of annualised salary arrangements that are provided for contractually.
Thank you. Thank you all for your time and for your evidence today. If you've taken any questions on notice, if you could please return those answers to the Secretariat by Monday, the 18th of May, 2026. That concludes today's hearing. Thank you to all of our witnesses who have appeared, and to Hansard and Broadcasting, and to the Secretariat for their assistance. Responses to questions on notice should be provided by the close of business Monday, the 18th of May. The committee stands adjourned. Thank you.